Good morning, sir. Please tell me your name.
Evan Burglary.
You're here in 21 CO 1436, charged with possession of alcohol on a street. Was there an offer in this case?
Yes, Your Honor, due to being a county ordinance, the offer would be an adjudication for time served.
I did have a chance to speak with Mr. Butcher, Your Honor, and I had a plea form ready for him to review, and I believe he wishes to resolve today.
Did you say he has reviewed it or it's ready for him to review?
He's reviewed. I gave him a copy of the plea form for him to review.
Okay.
And there's the one to sign in front of him. I believe he wishes to resolve today.
All right, sir, please raise your right hand.
Solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God.
Yes.
All right, sir. You had an opportunity to discuss with an attorney before court the rights you'd be giving up if you enter a plea of guilty or no contest today. Do you understand those rights?
Yes.
Do you have any questions for me about them?
No.
All right, you had to think about that. Do you have questions about something else?
No, yeah, I was just thinking about you saying I give up my rights to say guilty or not.
Not yet. So you're giving up your right to remain silent, which means I can ask you questions about the event. You're giving up your right to testify on your own behalf in a jury trial because we're not going to have one. So those are the rights I'm talking about.
Oh, thank you for
Yes, so
understanding.
those are the rights. Do you have any questions about that?
No, ma'am.
So you understand we're not having a jury trial.
Yes.
You're going to enter a plea and I'm going to sentence you today and the case will be over.
Yes.
All right. You understand if you're on probation anywhere for anything, this plea could violate that probation.
Yes.
You understand if you're not a U.S. citizen, you could be deported.
Yes.
All right, sir, understanding all of those things, at this time, how do you wish to plead to the charge of possession of alcohol on a street?
No contest.
I'll accept your plea, sir. There is probable cause here. I find your plea is freely and voluntarily made. Did you say it was an adjudication?
Yes, Your Honor.
At this time, I'll adjudicate you guilty, give you credit for the 3 days you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay those.
Okay.
Was there anything else, Ms. May?
No, Your Honor.
All right, good luck, sir. You have 30 days to appeal in writing.
So how does that work? Will that be?
Processing. Were we appointed in that case yesterday, Your Honor?
No.
Okay. Thank you.
You did appoint them? Okay. All right, good luck, sir. Have a nice day. Good morning, ma'am. Can you please tell me your name?
Tracy,
You're here in 21 MO.
scratching me.
Ma'am, you're here in 21 MO 1381, charged with violating state misdemeanors. Yesterday, Judge Bain addressed your case. You weren't here in court. He appointed an attorney to represent you. Mr. Brands, have you had an opportunity to discuss with your client?
Yes, I conveyed the offer to Ms. Robinson as well as a plea form to review.
Your Honor, I'm not sure why this case was reset yesterday. There is potential restitution. I don't believe this case should be pled today, even given that it is a city ordinance.
So there is no offer from the state?
No.
All right.
Would you,
All right.
Would you accept a plea to the bench, Your Honor?
Not likely. I want to hear from the state about the restitution. Ms. May, give me some more information about that.
Your Honor, the alleged allegations in this is that Ms. Robinson, I believe, grabbed a trash can lid, walked out of the store, threw the lid at the front window, breaking the glass of the Arena food store. There is no estimated damage or receipts or anything, given that this is 2 days old. I understand that it's generally a city ordinance, therefore we generally plea them. However, given that we have no idea what amount of restitution it is, and given that it's a city case, I cannot reach out to the store on their behalf to get a restitution amount. So I don't even know approximately how much that is or how bad the damage was. So that's why state's not conveying an offer at this time, Your Honor.
Well, and despite how it was arrested, it could be charged differently, and the victim would have a right to be here. Was the owner of the store notified about the hearing?
I don't believe so, Your Honor.
All right, I'm not going to accept a plea to the bench at this time.
We go home.
Ma'am, I am going to stay your bond. It's $250 with special conditions. You may not return to 635 North Westmoreland Drive. Do you know where the Arena food store is?
I don't understand anything you're saying, ma'am. You gotta repeat that.
Ma'am, why don't you understand me? Can you hear what I'm saying?
I'm trying to talk to you, ma'am.
Just put your hands down. They'll move the microphone for you.
I'm refusing to be in this courtroom right now.
You're refusing to be in the courtroom. All right, Mr. Brantz, are you waiving her appearance?
Your Honor.
All right. The bond stays and the condition stays.
Thank you.
Good luck, ma'am.
Good luck to you too.
I emailed you regarding, did you see it?
Good morning, sir. Please tell me your name.
Michael Bigley.
You're here in 21 CF 15056, charged with aggravated battery with a deadly weapon, domestic violence. There is probable cause. I'll appoint an attorney to represent you in this case. Does either attorney wish to be heard on bond?
Your Honor, it does look like he has a fairly short criminal history. I don't believe we have the victim here to testify today, so she's asking for a reasonable bond. Given that I believe the alleged weapon was scissors that the alleged victim had first. She's just asking for a reasonable bond, as well as there is an allegation of alcohol use, so as well as that condition.
I saw that. Anything, Mr. Brantz?
Just a reasonable bond, Your Honor, please.
All right, at this time, sir, your bond on this charge is $4,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes, ma'am.
You can't possess or consume any alcoholic beverages. All right, good luck, sir.
Your Honor, may I approach for the plea form?
Yes, thank you. Thank you. Please tell me your name. Good morning, sir. You're here in 21 CF 15090, charged with tampering with a witness to hinder communication to law enforcement and false imprisonment. There is probable cause. I'll appoint an attorney to represent you. Your bond is $5,000 on count 1, $150 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you may not coordinate that with the victim. Good luck, sir. Good morning, sir. Please tell me your name.
My name is Curtis Jones.
You're here in 21 CF 15086, charged with domestic battery by strangulation and domestic battery. There is probable cause. I'll appoint an attorney to represent you. Give me one moment. At this time, your bond is $5,000 on count 1, $100 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, this is my first time, but I guess no, nothing. Like, what about my kids? I'm sorry.
I'm sorry, what?
Like, we live together, so.
You can't now.
No, that's okay, but what about me still seeing the kids? I can't until this is done.
Well, I haven't said anything about the kids.
Okay, I just wasn't sure. I've never been in anything. I just want to make sure I'm following the rules right.
Right, so right now you can have no contact with the victim for any reason that includes the kids. But if there are children involved, you can talk to your attorney about ways that you can still be involved with the kids using a relative or something like that. But you can't send a message
That's fine.
to the victim about anything else.
I do have an older daughter that stated. Would that be okay? Or
What do you mean? How old is she?
she's 20, 21.
She lives in that house?
Yes, ma'am.
Was she there when this incident occurred? Is she a listed witness?
No,
Hold on, what's her name?
Kayla Jones.
Let me just look really quickly.
I didn't make note within the affidavit, Your Honor, of any of the children being present. So I'm unsure if they were or were not or witnessed anything.
And she's not listed on that back sheet. You can have contact with her, the 20-year-old.
Yes, ma'am.
All right.
That's really.
You can talk to her about the younger kids, but
Not about.
don't say to her, hey, I want you to tell your mom I said this. Don't do that,
Okay,
because that violates the court order.
you got it. Understood.
That's one of the ways you're not allowed to have contact. So I don't want you to unknowingly violate a court order.
Thank you.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but don't coordinate that with the victim. You talk to law enforcement, and then you go to the house with law enforcement.
Got it.
Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir.
Thank you.
No, because she's not a witness, so, I don't know. Please tell me your name.
Harold Monteith Jones.
Good morning, Mr. Jones. You're here in 21 CF 15057 because a warrant was issued for your arrest, charging you with battery by strangulation, domestic violence, and battery domestic violence. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you.
Your Honor, when setting bond, may I be heard?
Yes.
I just wanted to bring to your attention, he does have a 2018 misdemeanor bat DV that was no billed, the victim being Miss Jones. He also has a 2020 misdemeanor bat DV. Victim also is being Miss Curbello. He also has another 2020 bat DV. Victim in that one also being Miss Curbello. He had a 2021 bat strangulation DV and bat DV. Date of incident on that one was April of 2021. Victim being Miss Curbello.
Are any of those convictions?
No, Your Honor, they're all no bill due to the victim being unwilling. He also has a 2021 misdemeanor non-arrest bat DV, victim also being Miss Curbello. And Miss Curbello is the alleged victim within this case, Your Honor.
I see that. All right, thank you. All right, sir, your bond on count 1 is $100. Your bond on count 2 is $5,000. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. Do you need to return to that campsite? Do you have belongings there? All right, so I'll just order that you can have no contact with her. Are there any other conditions the state would request?
Your Honor, we just asked for a no return in case that is where the victim is staying.
Oh, let me look at the warrant really quickly. All right, I'll order that you're not allowed to return to that site. But yeah, I'm not gonna enter the others because it's a campsite. Yes, thank you. Good luck, sir. Do you have a question?
Well, I'm pretty sure by now I'm basically unemployed, so without this bond being paid, what's the limit of time I have to do?
Well, you're not sentenced right now. So your attorney can file a motion in front of the trial judge to reduce that bond at any time. So call the number on that green piece of paper and ask them to file a motion for you if that's what you want them to do. Good luck. Please tell me your name. You're here in 21 CF 15087, charged with aggravated assault with a deadly weapon and battery dating violence. There is probable cause. I'll appoint an attorney to represent you. Give me one moment. Your bond on count 1 is $2,500. Your bond on count 2 is $100. With special conditions, you can have no contact with any victim or witness in this case. Do you understand what no contact means?
But my daughter is there.
So you're gonna have to talk to your attorney about what to do with that, because I'm also going to order that you must comply with any plan set in place by DCF. You must maintain a separate residence from the victim, so that means you can't live in the same house. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand?
Yeah.
You have to answer out loud. I can see your head shaking, but we're making a record and the record doesn't reflect that. Who has your daughter right now?
I tried to let her dad get her, but they wouldn't let him.
You're gonna have to talk to your attorney and DCF about that because I don't know how I'm gonna order anything about that. All right, good luck, ma'am.
Your Honor, that is within the affidavit. I don't know if the father potentially just didn't come right before the PC statement at the end.
I saw it. That's why I don't think there's anything this court can do with that at the moment.
Understood, Your Honor.
All right, that's 21 CF 14860. Mr. Brantz, I'm going to appoint your office. It was a warrant, so PC has already been found, and the first offense is a punishable by life felony.
What was the reason for?
Hospital.
He's in the hospital.
We'll waive the appearance, Your Honor.
All right, thank you. Ms. May, did the state wish to be heard?
Yes, Your Honor. Given that count 1 is a punishable by life offense, state's asking that you hold him no bond as to count 1 and set reasonable bonds as to 2 through 8.
Any response from the defense?
No argument at this time, though. He is entitled to an Arthur hearing with his attorney as to count 1.
Yes, sir, I agree. Give me one moment. He'll have no bond as to count 1. Count 2 will be $1,000. Count 3 will be $4,000. Count 4, $4,000. Count 5, $1,000. Count 6, $5,000. Count 7, $10,000. With special conditions, he can have no contact with any victim or witness in this case, cannot possess a weapon of any kind, firearm or ammunition, may not return to the scene for any reason, or be within 1,000 feet of the victim's residence or place of employment.
Your Honor, I believe there's also 8 counts. There's also a bad DV as count 8.
Oh, you're right. $1,000 as to count 8. Are there any other conditions the state would request?
No, Your Honor, given that he's
Those
entitled to
counts?
no bond.
Right. All right,
You said 1,000 on 8?
yes. Good morning, sir. Please tell me your name.
Henry Callo.
You're here in 21 8300, charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Sir, you must look at me while you're in the courtroom or that wall.
Okay.
Good morning, ma'am. Did you wish to testify?
I need interpreter, please. Spanish.
Spanish? Just a moment.
Hello, Cisco Unity.
They must all be in other courtrooms.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
Good morning. I'm in need of your assistance with a witness in the courtroom, so just stay connected to the overhead, not the headset, please.
Yes.
Ma'am, please raise your right hand to be sworn.
Señora, por favor, levante la mano derecha para prestar juramento.
Do you solemnly swear and affirm that the testimony you're about to give should be the truth, the whole truth, so help you God?
Y promete que el testimonio que va a prestar será la verdad, solamente la verdad y nada más que la verdad, lo jura ante Dios.
Sí.
Yes.
Please state your name for the record.
Por favor, señora, diga su nombre para que conste en actas.
Yulisa Freire.
Yulisa Freire.
Thank you. Does the state have some questions for the witness?
Gracias. ¿La fiscalía tiene alguna pregunta que hacerle a la testigo?
Yes, Your Honor.
Sí, su señoría.
Good morning, ma'am. Can you please state your relationship to Mr. Callow?
I'm sorry, counsel, you said Mr.
Mr. Callow, C-A-L-O?
Señora, por favor, ¿podría decir usted qué relación tiene con el señor Carlos?
Es mi esposo.
He is my husband.
Are you afraid of him?
¿Usted le teme?
Ahora sí.
Now I do, yes.
Has anything like this incident ever happened before?
¿Algún incidente parecido a este había ocurrido en el pasado?
Siempre. Tengo dos veces que lo traje a corte y él me llamaba por teléfono y mandaba a su hermano para que hablara conmigo y le quite los cargos. Pero durante un año él abusó totalmente de mí, pegándome. Y yo no llamaba a la policía porque I love him. Pero ahora él tiene otra mujer y por esa mujer me pega. Tengo todos los pruebas.
Ma'am, just a moment.
Interpretar, señora.
I need you to speak in shorter sentences for the interpreter.
Señora, necesito que de ahora en adelante hable en oraciones más cortas para la intérprete. He used to call me. He used to try to get to me through his brother and ask me to drop the charges. And for the past year, he has been abusing me. And I did not call the police because I loved him. But now he has another woman and he's been hitting me because of this other woman.
And I have everything to prove. I come into my country and stay with him and he only wants sex with me. And he say, tú te quedas en la casa, tú sirves para limpiar, para cocinar, pero yo me voy a janguear con mis amigos. Y él abusa de mí mentalmente, me tiene destruida.
Señora, permítame interpretar. And then he says, you have to stay home and you have to cook and you have to clean and I'm going to go out with my friends. And he also mentally abuses me. I am destroyed.
Ma'am, you said you came from your country. Where are you from?
Señora, usted dijo que vino de su país. ¿De dónde es usted?
Perú.
I'm from Peru.
Do you want to have contact with the defendant while this case is pending?
Señora, mientras el caso está abierto, ¿usted desea tener comunicación con el acusado?
No, él abusa de mí mentalmente.
He mentally abuses me.
All right, I have no further questions, Your Honor.
Thank you.
No
Thank
tengo
you,
más
ma'am.
preguntas, su señoría.
Any questions from the defense?
¿Alguna pregunta de parte de la defensa?
No question, Your Honor.
Tengo preguntas, su señoría.
All right. Mr. Callow, your bond in this case is $1,000.
Señor Calo, la fianza de este caso son $1,000.
I speak English. Sorry.
But this is for her benefit.
Oh, okay, sorry.
Yo hablo inglés. Esto es para el beneficio de ella.
At this time, you can have no contact with the victim.
Yes.
Se le prohíbe todo tipo de contacto con la víctima.
No contact means you cannot speak to her, you cannot call her, you cannot text her on the phone, and you cannot send a message using a friend or a family member like your brother.
Yes, ma'am.
La prohibición total de contacto significa que usted no le puede hablar, no la puede llamar, no le puede enviar mensajes de texto y tampoco puede enviarle mensajes a través de terceros como sus familiares, amigos o incluso su hermano.
You can't possess a weapon of any kind, a firearm or ammunition.
Se le prohíbe la tenencia de todo tipo de armas, armas de fuego y municiones.
Él tiene un arma en la casa y yo no sé
He has
de
a
dónde
weapon
la
at
sacó. Yo no sé
And I
cómo.
don't know where he got it from.
Ya. Yo le enseñé al policía que él tiene un arma en la casa.
I showed it to the policeman. He has a weapon at home.
What kind of weapon?
¿Qué tipo de arma, señora?
Es una pistola que él trajo y cuando él tiene problemas conmigo, él la saca y la esconde para que la policía no la encuentre en la casa. Pero yo le enseñé que él la tiene en la caja fuerte de la casa.
It's a gun. He brought that gun to the house, and whenever he and I have problems, he takes it out of the safety box and he hides it, so the police won't find it. I showed it to the police when they came.
Did they take the weapon, the police?
La policía se llevó el arma.
No, la dejó en la
No.
casa.
They left it at home.
Do you know where it is?
¿Usted sabe dónde está?
El arma
The weapon?
Yes, right now, do you know where the gun
in
is?
the house.
Sí, ahora mismo. ¿Sabe usted dónde está?
Sí, en la caja fuerte de mi casa, que él la puso ahí. Él tiene balas, él compra ilegalmente balas. Y lo tiene en la caja fuerte. Y esa pistola la tiene ahí. Pero yo sé que eso es ilegal. A él le gusta hacer cosas ilegales. Él
Ok, señora,
toma
permítame,
mucho.
permítame interpretar, señora.
Ujú.
Yes, it's at home. It's on a safety box, and he has it there. He also illegally buys ammunition for this gun, and he has this gun illegally also. He likes to do illegal things.
Can you open the safe?
Yeah, I'm open the safe for the police. For he see the gun.
All right, so for the attorneys, I would order him to surrender the firearm within 24 hours of his release, but
Bueno, esto me dirijo ahora a los abogados. Le ordenaría a él entregar este arma en un plazo de 24 horas luego de ser puesto en libertad, pero
I don't think I have jurisdiction to order her to do that.
no creo que yo tenga jurisdicción para ordenarle a ella que lo haga.
No, Your Honor, I don't believe so. However, according to her address, she does live at the same location.
Yo no creo, su señoría, pero según la dirección, ella vive en la misma casa.
What I can, oh, sorry.
So just given that she lives in the same location and she's heard this conversation, arguably she could do it. I don't believe this court would order her to due to jurisdiction. But the state would still ask that you do a surrender within 24 and no weapons, firearms, ammunition. In the event that the victim does not do it before the defendant is released from custody.
Bueno, como ellos viven en la misma casa, usted no tiene la jurisdicción para ordenarle a ella que entregue el arma, pero ella por su cuenta, si desea, podría hacerlo.
Sí.
Yo lo que le solicitaría a este juzgado es que se le prohíba la tenencia de armas al acusado y que se le ordene que la entregue en un plazo de 24 horas luego de ser puesto en libertad, si es que ella no lo ha hecho antes.
Or,
Disculpa. Él me amenaza con una gente que es bad people en Kissimmee, que si yo digo algo del arma o de las balas que él va a mandar a matar a mí. Eso lo dice cada vez que se va, es un barbero donde venden drogas, donde hay un puterío ahí al lado y todo eso me
señora,
amenaza que si
permítame.
yo hago algo, él me manda a matar con esa gente.
He threatens me. He has told me that he knows some bad people from Kissimmee. It is a barber shop where they sell drugs. There's also prostitution there. And he has threatened to send those people to kill me if I say something about these illegal weapons or ammunition.
Your Honor.
All right, here's what
Can we approach?
yes, just a moment.
Señoría, ¿me permite abordar? Un momento, por favor.
Thank you, Your Honor.
All right, here's what I'm going to order. Mr. Callow, you must maintain a separate residence.
Bien, esto es lo que voy a ordenar. Señor Carlos, se le prohíbe la convivencia con la víctima.
I'll allow a one-time return with law enforcement to gather belongings.
Se le permitirá regresar en una ocasión acompañado de las autoridades para recoger sus pertenencias.
At that time, you must surrender the firearm to law enforcement.
Y en ese momento usted deberá entregarle a las autoridades el arma de fuego.
Are there any other conditions the state would request?
¿Hay alguna otra condición que solicite la fiscalía?
No, Your Honor.
No, su señoría.
All right. Good luck, sir. Thank you, ma'am, for coming. Good luck.
Thank you.
Muy bien, buena suerte,
¿verdad?
señor. Gracias, señora, por venir.
Just a moment, Your Honor.
Okay. Is that all we have for the interpreter at this time? Corrections, is there anything else for the interpreter at this time? Not behind, okay. Can you ask them if they have any other victims that need the interpreter?
I believe the interpreter can ask the gallery.
Oh, they can hear her?
Yeah.
Oh, could you
believe
ask
so.
if there's anyone else who needs your assistance?
¿Alguna de las personas que se encuentran presentes necesitan los servicios del intérprete al español?
No hands, Your Honor.
I see no response. Thank you so much.
Thank you, Your Honor. May I have his case number?
21MM8300.
Thank you.
Your Honor, may Mr. Halo ask the court a question?
Yes. Oh,
Halo, excuse me.
go ahead.
Yes, ma'am. We own two cars. One car is completely in her name, which is the black BMW, the 320i, and the second car, which is the BMW X5, is in both our names. The reason why it's both in our names is because she has a better credit score, and I'm the one that bought it. So I'm wondering if you could honor me to have the car that's in my name, and she keeps the other car. That's the only way. I need a car to get to work back and forth.
I'm not a family law judge. Is the interpreter still on the line?
Yes, I'm still here, Your Honor. Do you want me to interpret?
I believe she's
Yes, please.
still here.
I just want to make sure she hears this.
Su señoría, tengo una pregunta. Es que nosotros tenemos dos vehículos. Hay un vehículo que está a nombre mío solamente y hay un vehículo que está a nombre de ambos porque ella tiene mejor historial de crédito que yo. Yo quisiera saber si se me podría permitir conservar el vehículo que está a mi nombre para poderlo utilizar para ir al trabajo.
I think what will happen when you return with law enforcement is they'll allow you to gather things that belong to you.
Yo creo que lo que sucederá es que cuando usted regrese acompañado de las autoridades, ellos le permitirán a usted llevarse las cosas que le pertenecen a usted.
If you have a title to the car and it proves that you're owner of the car, I think they'll allow you to take it.
Si usted tiene el título del vehículo que demuestre que usted es el dueño del vehículo, yo creo que ellos le permitirán que usted se lo lleve.
No, él no tiene el título.
The car is
No, he
financed.
doesn't have the title.
The car is financed with both our names on it. She has the first car, which is the black BMW, is completely in her name. She's full owner of it. The second car, which is the silver X5, it's in both our names. And the reason why, like I said earlier, the reason why it's in her name as well is because she has a better score. When my car was in crash, I bought the money that I got for the total of my car. I bought it with the BMW.
No,
So for me to go, for me,
Hold on, let her
I'm sorry.
interpret this. We have to do it.
Pero lo que sucede,
I'm sorry.
Lo que sucede es que tenemos dos vehículos. El primero es un BMW negro que está a nombre de ella solamente. Entonces el otro, el vehículo plateado, está a nombre de ambos. Ese vehículo todavía se está pagando. Lo que sucede es que cuando mi vehículo, yo tuve el accidente y compré el historial de crédito de ella era mejor, así que necesité que ella estuviese también en la documentación del vehículo.
Let me ask the attorneys your thoughts on
eso no es verdad.
the court's jurisdiction.
May we approach, Your Honor?
That is not true.
Yes, just a moment. All right. Sorry for the interruption.
Muy bien, disculpe la interrupción.
I think you're going to have to resolve that with law enforcement when you return to the scene that one time.
Señor, creo que eso usted tendrá que resolverlo con las autoridades cuando regrese a la escena en esa ocasión.
And or at a later time in front of a family law judge.
O en una ocasión posterior ante un juez de familia.
So good luck, sir. Thank you, ma'am. Good luck.
Thank you.
Buena suerte, señor. Gracias, señora. Buena suerte.
Una pregunta. Ese carro
One
que él
question.
dice que está pagado, eso lo compré yo con mi dinero. Y el segundo carro que él habla que estamos pagando, lo pagamos los dos. Yo trabajo, le doy dinero a él y él ahora me lo quiere quitar porque el otro carro no está en la casa. Se lo llevó a un mecánico. Yo no tengo carro. Yo necesito...
Okay, ma'am. Again, short sentences because I need it interpreted.
Señora, recuerde que tiene que hablar en oraciones cortas para que lo puedan interpretar. That car he's talking about, the one that's already paid in full, I paid it myself. Then the second car, I also pay for that car. I work and I give him money. The first car is not at home right now. He took it to a mechanic to be fixed. So if he takes the second car, I would be left without any car.
Ma'am, that's why I'm not ordering any of that today.
Señora, es por eso que yo no estoy ordenando nada al respecto hoy día.
Okay.
That determination can be made by law enforcement at the scene.
Esa determinación la podrán hacer las autoridades en la escena.
or at a later time in front of a judge who has jurisdiction over those matters
o en una fecha posterior en el tribunal ante un juez que sí tenga jurisdicción sobre esos asuntos
and who will have evidence of ownership of the vehicles.
y quien tendrá ante sí comprobante de quién es el dueño de los vehículos.
Sí.
I have none of that information today.
Ok, lo
Hoy
único que
día
quiero
no tenemos esa
asegurarme,
información.
lo único que quiero asegurarme es que él no me deje sin carro, porque él ahorita como anda con otra mujer, entonces yo me quedo en la casa sin carro, sin moverme para comprar comida ni nada, y él feliz de la vida. Y no es justo.
Señora, permítame interpretar. Well, I just want to make sure that he won't leave me without a car because right now I stay at home and he takes the car to go out. But since he's going around with this other woman, he doesn't care and I don't want to be left without a car. It's not fair.
So it will have to be a determination made based on who can prove ownership of the cars. I don't have that information.
Yeah, this is
Esa
my name first and
determinación,
his second.
señora, permítame interpretar.
Ajá.
Esa determinación se tomará posteriormente tomando en consideración quien pueda demostrar titularidad sobre el vehículo.
Somos los dos, pero yo soy primero y él segundo.
Both of us, but I'm first and he's second.
I'm not sure what law enforcement will do with that at the
Yo
scene.
no estoy segura qué harán las autoridades con eso en la escena,
But I don't have the ability to order anything about that today.
pero yo no tengo la capacidad de ordenar nada al respecto hoy día.
Okay. Cuando llegue la policía, que él se dé cuenta, tiene los papeles, hay todo, tengo las evidencias de todo, del engaño, de que él metió a la otra mujer a mi casa, que él la subió en el carro a mi casa cuando yo pago el carro con él. I have everything
Señora,
to prove.
permítame interpretar. Well, when the police come, I will be able to show to them all the proof I have of who are the owners of the car and of the cheating that has been going on, that he took this woman and into this car that I pay for, and then they were also inside my home.
Ma'am, I'm really sorry for that situation.
But
I can't change that here today.
Señora, yo lamento mucho esa situación, pero eso no lo puedo cambiar.
Okay, yo voy a hablar con la policía, porque yo no me puedo
Okay, I will
creer
talk to the
nada.
police.
Just make sure both of you have all the information you need when he returns with law enforcement.
Por favor, asegúrese de que tengan ambos toda la información que necesiten para cuando él regrese con las autoridades.
Las placas están a mi nombre. The plate is my name. Okay.
Place her under my name.
Thank you very much.
Yes, ma'am. Good luck. I'm sorry.
Gracias, señora. Buena suerte. Lo siento mucho.
Good morning, sir. Please tell me your name.
Daniel Garcia.
You're here in 21 MM 778, charged with battery. There is probable cause. I'll appoint an attorney to represent you in this case. Does the state know when the kidnapping false imprisonment conviction was?
1 second, Error.
And was that the same victim?
That was almost 13 years ago, ma'am.
Okay.
That was a long, long,
It
long
was a long time ago. All right.
I've been clean almost 12 years now. Well, almost 10 now.
And I do, however, have a 2021 misdemeanor felony non-arrest from, looks like October is when we received it, of intimidation,
That was dropped.
written and threats. It's the same victim. It was an F2. The victim did decline to prosecute. I also
Alright.
have a 2021 felony non-arrest Aggravated, pregnant person DV F2. It's a different victim. There, did you say the robbery armed with a weapon?
I did.
That was 2011?
It says it's a juvenile.
Well, there might be more juvenile, Your Honor.
Is there another one?
I have a 2011 felony robbery armed with a weapon, false imprisonment with a weapon, possession of a concealed weapon by a convicted delinquent, ag assault with deadly weapon, and battery. In that case, it looks like he only pled to the false imprisonment with a weapon, the F2. The kidnapping I don't see within orange. I can check CCIS.
It's all right. I'm taking him at his word that it was 13 years ago. All right, sir, at this time, your bond on this charge will be $500. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. You understand?
Yes, ma'am.
Right. I'm also ordering you can have no contact with any witness. I thought I recall there was a witness in this case.
I believe there were 3, Your Honor.
Okay, 3 witnesses. So no contact with any witness either.
Yes, ma'am.
All right, good luck, sir. Please tell me your name. Good morning, ma'am. You're here in 21 MM 571, charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you in this case. Good morning, ma'am. Did you wish to testify?
Well, I'm her mom.
Do you want to say anything?
I would just.
If you do, I need to have you sworn in.
Oh, yeah, okay.
Raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you. Please state your name for the record.
Shanae Hairston.
All right, I'm going to let the prosecutor ask you some questions.
Ma'am, can you repeat your first name again?
Shanae,
Thank you. And what is your relationship to Tanae Hairston?
my child.
Are you afraid of her?
No.
Has anything like this ever happened before?
Yes.
Approximately how long ago would you say the last time was?
This is repeated situations, but this is the first time she has put her hands on me.
Okay. And do you believe drugs or alcohol were involved in this incident?
No.
And do you want to have contact with her while this case is pending?
Limited contact. She can't stay at my home. She's gonna have to find her someplace to stay.
Is there anything else you'd like to tell the court?
I would advise that she has mandatory therapy.
What kind of therapy?
Anger therapy.
Mm.
Since sixth grade, she has, if you look at her school record, she has gotten into at least 2 fights every school year. She just had a fight so far this year in her senior year twice, where she's had to get suspended. Plenty of times when I've had to take up for work, like these past 2 days, knowing that currently I'm working as a temp and working part-time, you know, because I caught COVID back in July, and the job I was working at temp for 2 years, and they laid me off because I got COVID.
I'm sorry.
So it's hard to see like this because of the fact that it's my firstborn, my first child. She looks just like me. Her birthday is November 12th, mine is November 15th. So it's hard to see her in this way. But she has no respect for me. I left an abusive relationship, which as a result, I have a 14-year-old son from that relationship. And it's so crazy because just the other day he told me to shut up. All the way in South Carolina. Because he couldn't pay the $58 a week. Her father is in child support $15,000. So When I left that abusive relationship, it was me and my 2 kids with just the clothes on my back. And a year ago, I finally got my own apartment. Finally. So this is hard for me right now. This is very hard for me right now.
I'm sure.
Because I just... She has been with me through shelters. And even though we have been close to the streets, I have never had her in the streets. I may have to put up with a couple of males just to make sure that my kids don't sleep underneath a bridge. And I just really feel like she just don't respect that. I really don't. And for her to put her hands on me, all because of the fact that all I require of her, even though she has her own money and her own job, she pays no bills. I don't ask her for a cent. All I asked for her judge was to do the dishes before she go to bed and to keep the bathroom clean. That's it. I don't want no rent. I don't want her to help me with the bills. I feed her. Judge, I've been struggling, so this hurts even more. Because now I have to figure out how I'm gonna make up these days because I'm a temp, so I don't get paid time off. But she doesn't respect me, and I can't have her in my home, and I have to be sane, and I can't have it where I want to end my life and I have another child.
No, you definitely can't have that.
But this is hard for me.
I'm sure.
We're so close. Our birthdays are so close. Our ages. She just turned 18. I turned 38. We're forever connected.
Well, you are because you're her mother. And Ms. Hairston, this is a tough wake-up call for you because you're 18 now. You're no longer a juvenile. And in the state of Florida, if you touch someone against their will, it's a crime. Battery is a first-degree misdemeanor charged, punishable by up to a year in the county jail. So this isn't juvenile anymore. You're an adult now. Now, I don't know what the state is going to do with this. It's the state of Florida versus Tanae Hairston, not your mother versus Tanae Hairston. So it's up to the state of Florida what they're going to do with your case. But I can tell you, just from the few minutes that your mom has spoken today in court, it seems like you have the support of a pretty wonderful person who has fought through a lot of hard times, and life is hard, right? Everyone's life is hard. Life is hard. Bad stuff happens to all of us. But at this time, I'm going to order that you not have any contact with your mother. This might be a good time to see if you can get some help. Ma'am, I heard what you asked for. Because I'm not sentencing her, I don't have jurisdiction to order her into any kind of anger management, but I'll ask both attorneys if you can make notes for your colleagues about that. And I believe that's typically part of any kind of plea agreement anyway, but they'll make notes for their colleagues. Ma'am, your bond is $500. You can have no contact with the victim. You also can have no contact with your 14-year-old brother at this time. Do you understand that?
Yes.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. That means you can't live with your mom right now. I'll allow you to return one time with law enforcement to gather belongings, but you can't call your mom to set that up. Do you understand?
Yes.
Are there any other conditions the state would request?
No, Your Honor.
Good luck, ma'am. Thank you for coming, Ms. Hairston. Good luck.
Your Honor,
Yes.
I was informed there's a victim. If we can recall, Andrew Townsend, there was a victim present. I don't know if they're still here.
Okay, let's do this one and then the clerk is gonna pull that, yes, is gonna pull that back up for me. Okay. Yes, he's a witness. That's why I said that. Come on up with him.
Sorry, Your Honor, Lopez Pacheco was behaving.
All right, 21 MM 8282. Mr. Brantz, I'll appoint your office.
Waive the appearance, Your Honor.
Bond is $500, no contact with the victim, not return, no weapons, firearms, or ammunition. Actually, I'll say maintain a separate and allow a one-time return.
Your Honor, is this witness for Lopez or Townsend?
That's for,
Good morning, please tell me your name.
It's Adrian Paris.
21 MM 8274. You're here charged with battery, dating, violence. There is probable cause, and I'll appoint an attorney to represent you. Good morning, ma'am. Did you wish to testify?
Yes.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Do.
Please state your name for the record.
Aggravated.
Sir, you look at me while you're in this courtroom or that wall. Don't look at the witness. Do you understand?
I had one.
You have to answer out loud.
Understood.
Thank you. All right. Does the state have any questions for this witness?
Yes, Your Honor. Good morning, Ms. Crometti. What is your relationship to Mr. Paris?
He's my fiance.
Are you afraid of him?
No.
Has anything like this ever happened before?
No.
If anything like this or anything more severe where you ever felt threatened ever occurred in the future, would you feel comfortable calling 911?
Would I be comfortable with?
If anything like this or anything more severe to where you felt threatened ever occurred in the future, would you feel comfortable calling 911?
Oh, yeah.
Do you believe drugs or alcohol were involved in this incident?
No.
And do you want to have contact with Mr. Paris while this case is pending?
Yes. I also wanted to know, do I get a say in dropping charges or no?
So the way this works is it's the state of Florida versus Adrian Paris.
Okay.
It's a crime against the state of Florida.
Okay.
So because you're the listed victim, I would imagine the state is very interested in talking to you. But no, you don't get to drop the charges. People say that, and I think we hear it a lot on TV, but that's not how it works in real life.
Okay.
It's up to the state whether they're going to file the charges or not.
Okay.
But if I was the prosecutor, I'd be very interested in hearing what you have to say.
Okay.
All right, any questions from the defense?
No questions, Your Honor.
Anything else, Ms. May?
No, Your Honor, but I am going to give her a card so she can contact the state attorney's office.
All right. At this time, sir, your bond is $500. With special conditions, you can have hold on one moment. Based on the testimony here today and reading the affidavit, I'm going to allow you to have peaceful contact with the victim. Do you understand what peaceful contact means?
Can you further explain, please?
Yes, sir. No hostile contact, no shoving, no fighting, no grabbing, no hitting, no pushing. Don't even raise your voice. Do you understand?
Understand.
So if there's an argument, you need to turn around and walk away because you're the one who can be arrested and held at no bond for violating a court order. Do you understand?
Understand.
All right. You can't possess a weapon of any kind, firearm or ammunition. And I'll order that you can't have any contact with any witness in the case. Good luck, sir. Thank you, ma'am. Good luck.
Thank you.
Your Honor.
Yes.
There's also a witness for Lopez Pacheco. So we have two witnesses with absent defendants.
All right. Were they here at 9 and we just didn't know it?
yes.
Okay. All right. Do you have Townsend? All right. Bring in the victim for State of Florida versus Andrew Townsend. Good morning, ma'am. This is 21 CF 14860. I understand you're a victim or a witness in the case against Andrew Townsend.
Yes, I'm the victim.
All right, please, do you wish to testify?
Yes, ma'am.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I swear.
Thank you. Please state your name for the record.
Sandra Townsend.
All right, and just so you are aware, ma'am, he's not here today. Oh, you heard that earlier.
I heard that earlier. However, when they called me this morning, I didn't even get the message until 8:25, and it took me almost 35 minutes to get here.
Okay, that's fine. I just wanted to make you aware that that's why he's not in the courtroom. Normally he would be, but he's not.
Yes.
All right, does the state have questions?
Yes, ma'am. Good morning, Miss Townsend. Can you please state your relationship to Andrew Townsend?
I'm his wife.
Are you afraid of him?
Yes.
And has anything like this ever happened before?
Not to this extent.
Have there been verbal or physical disagreements between the two of you?
Yes, this would be my second injunction that I had filed on him. The first one was dismissed due to him attending a drug rehab. And then there was no violence until just this year.
Understood. And to your knowledge, is that injunction that you recently got still active?
I was given a permanent injunction for 6 years yesterday
Thank
with no contact with myself or our 12-year-old daughter because she is also a victim.
And do you believe drugs or alcohol were involved in this incident?
No alcohol, but possibly drugs.
And do you want to have contact with him while this case is pending?
No, none.
That's all I have, Your Honor. I don't know if you just mind telling her the conditions that were previously set. State's asking for no modifications.
All right, Mr. Brantz, any questions from the defense?
No questions, Your Honor. I concur with the state about the repeat of bond conditions.
I'm sorry, what?
I concur with the state about the repeat on bond conditions.
I will do that, but I'm actually going to add, I'm sorry, I'm going to amend this. Okay.
Would I be able to say something real quick?
I'm sorry?
Would I be able to say something?
Yes, ma'am, you can say anything you wish.
Okay, was currently on a bond from Marion County for an incident that happened this year, and his trial date is set for March, so he's already violated the fact of being on a bond. He was served the temporary injunction on the 12th and still came to our home with a gun. He's not going to follow any rules that are given to him, which is why my daughter and I are currently at the Harbor House because we are afraid to go back to our own home.
I'm so sorry about that, and I understand. Do we have that he's on bond in Marion County?
No, if he was, we couldn't place a hold for that county.
Do you know what the charges are?
It was grand theft auto.
Okay. So in Marion County, they can revoke that bond and hold him at no bond.
Okay.
On this case, count 1, he has no bond.
Okay.
He's being held with no bond currently. He
Okay.
can't bond out on that count. So even though I gave him monetary bonds on the others, because he's entitled to it by law, I have to give him bonds on the ones to which he's entitled bond. He still can't bond out because of count 1.
Okay, thank you.
Now, what will likely happen is his attorney will likely file a bond motion in front of the trial judge and ask the judge to set a bond. So there will be another hearing in front of another judge.
Okay.
You'll be notified of that hearing. You have a constitutional right to be there, but that hearing is likely pending, just so you know.
Okay.
On count 2, his bond is $1,000. Count 3, it's $4,000. Count 4, it's $4,000. Count 5, it's $1,000. Count 6, it's $5,000. Count 7 and 8, it's $1,000 each. So it's
Oh, I was here when you gave that. I didn't realize that's who you were discussing at the time.
that's him.
Okay.
So that's 17,000 total.
I thought you did 10 on count 7. Did I miss?
Oh, I did do 10. Sorry, not 1. So that's 27,000 total. But again, he can't bond out on count 1 right now.
Okay.
So he'll be held with no bond. The conditions I ordered were he can have no contact with any victim or witness in the case. He may not return to the scene for any reason. He's not allowed to possess a weapon, firearm, or ammunition. I'm going to add no contact with any minor child under the age of 18. And comply with any plan set in place by DCF. As well as cannot possess or consume any controlled substance without a valid prescription, subject to random drug screens. And just for your information, at this time, the trial judge is Judge Bob LeBlanc.
Okay.
So that's who will be seeing his case later, downtown at the courthouse.
Okay, but not today, obviously.
Not today, no.
Okay, thank you.
Do you have any other questions?
No,
Yes, ma'am. Good luck.
thank you.
All right. Do we have the victim in Lopez? Okay. Good morning. Are you here in the state of Florida versus Jose Lopez Pacheco?
Yeah.
All right, that's 21 MM 8282. We've already addressed his case. Can you please tell me your name?
Monica Thompson.
And did you wish to testify?
I do.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Please state your name for the record.
Monica Thompson.
Let me ask if the state has any questions.
Yes, good morning, Ms. Thompson. And what is your relationship to Mr. Lopez Pacheco?
This is my fiance.
Are you afraid of him?
No, ma'am.
Has anything like this ever happened before?
No, ma'am.
If anything like this or anything more severe where you felt threatened ever occurred, would you feel comfortable calling 911?
Yes, ma'am. I told the police officer that whenever he was there.
Do you believe drugs or alcohol were involved in this incident?
No, ma'am, they weren't.
And do you want to have contact with him while this case is pending?
I really would like to.
Okay. Is there anything else you'd like to tell the court?
Just, he's not violent like that. I don't understand why you guys even arrested him. He literally didn't do anything, so I don't.
Well, ma'am, none of us were there. We guys didn't arrest him. Law enforcement arrested him because someone called 911. And when they came, I read the affidavit. When they came and investigated, even Jose said he pushed you.
Right.
So that's a crime in the state of Florida. So that's why they arrested him.
Okay. No contact. This is our first, this is his first offense. So why are we not allowed to have contact?
So in all domestic violence cases, if I don't hear from the victim in court, I order no contact. Sometimes even when the victim asks for contact, I still order no contact. It's based on the circumstances present in the affidavit as well as the defendant's criminal history. I need to look this up. Rebecca, do you have his face sheet by any chance? Easily accessible.
We've lived together for a year now and I've never had any problems or issues. This is the first thing that's ever came up.
I'm looking at the face sheet and it shows no criminal history. I'm concerned about his behavior this morning, though. What says the state as to contact?
Your Honor, state shares the same concern. I'm not aware of why he was a behavior refusal this morning. However, given that the allegations within the affidavit are, that it does look like to be a push to get the victim out of his way, and then she hit the door, and the victim is testifying that she wants contact, I'll leave it within your discretion whether you want to set a no hostile. State has no objection.
Ma'am, I'm concerned that he's behaving in such a way that he cannot be brought to court this morning. That's a red flag for this court, especially in a domestic violence case. However, I did review his record. At this time, I see no prior convictions. I reviewed the affidavit carefully. Based on your testimony today, I'll allow him to have peaceful contact with you. So strike the maintain and the one-time return. I hope that works out.
Thank you.
Good luck, ma'am.
Thank you.
And you're maintaining the no weapons?
Oh, yes. But I'm just changing the contact, which means I'm changing the maintain separate.
Understood, Your Honor.
Good morning, ma'am. Please tell me your name. 21MM8283. You're here charged with battery, dating, violence. There is probable cause. I'll appoint an attorney to represent you. Sir, do you wish to testify?
Yes.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do.
Thank you. Please state your name for the record.
Travis Griggs.
I'm having a really hard time hearing you. If you could get closer to the microphone.
Oh, Travis Griggs.
Thank you. Go ahead, Miss May.
Good morning, Mr. Greggs. What is your relationship to Miss Powell?
Soon to be wife.
Are you afraid of her?
No, ma'am.
Has anything like this ever happened before?
No, ma'am.
If anything like this or anything more severe where you felt threatened ever occurred, would you feel comfortable calling 911?
Yes. I will.
Do you believe drugs or alcohol were involved in this incident?
No.
And do you want to have contact with her while this case is pending?
Yes.
Right. Is there anything else you'd like to tell the court?
Can this be dropped? It was a misunderstanding. That's all. I mean, somebody was riding by and they seen us, and I guess they thought what was going on, but it really wasn't. So when we got home, everything was fine. Everything was really fine, and then the police officers just came in. I don't know.
So it's up to the state of Florida whether they file the charges.
Okay.
It's not really up to you. This is the state of Florida versus Crystal Powell.
Okay.
So Miss May just gave you a card. You can get that on your way out. It's in that thing for you to pick up. Because I'm sure that the state attorney will want to hear from you because you're the listed victim, but it's up to them whether they're going to file this or not. I have no idea.
And all the information that I need is on that card.
The phone
call.
number as well as the case number, which is what they'll ask you for.
All right. Is she gonna have a bond or something? Can we get her out?
Yes, she will have a bond. Well, I don't know. Hold on a minute.
She does have an out-on bond.
Right. She will have a bond, but I don't know that she'll be able to bond out today because she's currently out on bond for a charge of petty theft.
They threw that out.
I don't think so. It looks like it's pending a pretrial diversion program, but nonetheless, it is still an active case. And while you're out on bond or have been released on your own recognizance in a criminal case, if you get arrested for a new criminal case, the judge can revoke that bond. So let me address this case first. Ms. Powell, your bond in this case will be $500. Based on the testimony here today, I am going to allow you to have peaceful contact with the victim. Do you understand what that means?
Yes, ma'am.
No hostile contact, no pushing, no shoving, no hitting, don't even yell, no raising your voice. You can't possess a weapon of any kind, firearm or ammunition. You cannot have any contact with any witness in this case. I'm still inclined to revoke that bond, Mr. Brantz.
May I have a moment to confer to ask about the
Yes.
trial diversion? Your Honor, that pretrial diversion program does have a start date of December 1st. She has an appointment December 1st, and she has been working with our office. If you're not inclined to take no action, I would just perhaps have you revoke and double due to her participation in that program, working with our office and with witness testimony today.
What says the state?
Your Honor, state is also asking that you revoke and double and not revoke and set at zero at this time. Both are, or she's out on bond for a nonviolent offense.
Okay.
It does seem like she has no other criminal history. That case did come in with 2 additional counts, however, state did not file on them.
What were they?
She had children with her. They were contributing to the delinquency of a minor when scanning the items. However, it is a nonviolent offense, and she does qualify for PTD and was approved for PTD recently. So say she's asking that you revoke and double the petty theft instead of revoking and setting at zero.
Mr. Brantz, does your client have a job?
She's a security. She works with Garter Security as a security officer for the last 3 years, she told me.
Oh. All right, I'll do that then. I'll revoke and double that bond. Do you know what it was? Anybody?
It wasn't a bond. It
You're-
came in at a summons.
Yeah, the summons case.
Information was filed. Never arrest.
It was never arrested, so she's not actually out on bond?
Can I say something to that?
I'm sorry?
No, I say, can I say something to that?
Yes, sir.
All right, that situation right there, we are already like, it was, we had to go to a COI. So
Right.
it was really a misunderstanding. It really wasn't supposed to be her. It was her friend, the one that was doing it. But yeah, they had it on camera. You can barely even see her doing anything, but you see her friend in the back. So I guess it was like kind of like guilt by association because the kids was with me. So when I came around the corner to get them, that's when it was like a secret shopper or something.
Yeah.
They was trying to stop her friend, but they got them mixed up just by their hair. And they grabbed her instead of grabbing the friend. So it's really like
All right, well, just based on the fact that she's not out on bond, I'm going to take no action on that case. All right, good luck, ma'am. Thank you, sir. Good luck.
all right. Can she get out or?
She can.
All right, thank you. I love you, Crystal.
Yeah, the bond you said on the DV was 500.
Good morning, ma'am. Please tell me your name.
Will Marie Joseph.
You're here in 21MM8298, charged with battery, dating, violence. There is probable cause. I'll appoint an attorney to represent you. Good morning, sir. Do you wish to testify?
Yes.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Orsino Josham.
I'm sorry, what was your name?
Orsino Josham.
Thank you.
Good morning, sir. Can you please state your relationship to the defendant?
Yeah, she's my girlfriend.
Are you afraid of her?
No, I don't. I'm just gonna keep answering the questions.
Do you want to have contact with her while this case is pending?
Yes, I don't even know why there's a case because I didn't call about no aggravated assault or domestic violence. She's the one that called, so it's like, why is she even in there? So this don't make no sense to me at all. She ain't saw me, she ain't do nothing.
So she was arrested for battery, domestic violence, not aggravated assault or whatever it was that you
I
said?
didn't even know she was being locked up until they came in at the end and basically told me, oh yeah, we taking her in. By that time, she was already in the car.
So law enforcement responded to a 911 call about a disturbance. So if it wasn't you, it means someone else heard what was going on and called law enforcement.
All
That's why they responded.
But that person got everything completely wrong then because she ain't do nothing to me at all.
All right, any other questions, Ms. May?
No, Your Honor.
Anything from the defense?
No questions, Your Honor.
All right, give me one moment. There is still probable cause. Hold on one moment. All right, at this time, ma'am, your bond is $500. I'm going to allow you to have peaceful contact with the victim. Do you understand what that means? No hostile contact. No shoving, no throwing things, no hitting each other. Don't even raise your voice. You understand?
Yes.
You can't possess a weapon, firearm, or ammunition. Good luck. Good luck, sir. Did you give him the information? Okay, thank you. Sir, please tell me your name.
Gerald Taylor.
Mr. Taylor, you're here because there was a warrant out of Jackson County. Hold on, I have to look this up.
Excuse me too, ma'am.
Yeah, just give me a minute. I gotta go to another place on the computer. All right, Gerald Taylor, out of county warrant, Jackson County Sheriff's Office. Warrant is active. Hold on. VOCO, order of contempt and writ of attachment for failure to comply with genetic testing. Oh, it's a violation of a court order. A court ordered you to submit to genetic testing. And so this is a warrant for violating that court order. At this time, there's no bond on that. Case number 19380CA. All right, I'm going to appoint an attorney to represent you, and we'll notify Jackson County that you're here.
Is it that they just want my DNA?
It says genetic testing.
Yes, it's
I don't know if it's DNA.
about a kid or something, I think.
Right. But I don't have the actual, what the court ordered, so I can't give you any more information. But I'm gonna appoint an attorney to represent you so that they can talk to the attorney in Jackson County as well. Maybe they can get more information, but we'll notify Jackson County. They said that they'll transport within Florida, so they'll come and get you. Man, that was really confusing. Good morning, ma'am. Please tell me your name. You're here for violating probation in case number 20 CF 13767. The allegations in the affidavit are that you violated by failing to undergo a drug evaluation, failing to remain at your residence as ordered, failing to successfully complete 100 hours of community service, failing to complete the impulse control class as ordered. Looks like that's all of the allegations. At this time, there's no bond, and I'll appoint an attorney to represent you.
Your Honor, can Ms. Faircloth be heard?
She can say anything she wants. Ms. Faircloth, you understand that everything you say here is being recorded and can be used against you later?
I take care of my father. He has stage 4 kidney disease. I fix his meals. I give him his medications, so on and so forth. It's imperative for me to be home. I really need to get a bond. Like my children will be there. Like this evening, I have started to do all of those things that were mentioned. I have the proof of complying with them. I'm not completed all of them, but he gave me my entire terms of my probation to finish those things. So I hadn't finished them, but I had started all of them.
Ma'am, you're gonna have to take that up with Judge Wooten. That's who signed this warrant, and he didn't authorize a bond. And according to the affidavit, it says that at the time this warrant was issued, which was in October, you had made no attempts to comply with any of it and had in fact a positive drug test for methamphetamines. So the probation officer is recommending that you remain in the county jail until a bed can become available in a treatment facility. So I'm not going to change Judge Wooten's warrant. You're going to have to address it in front of him. Ask your attorney to get you in front of him as soon as possible. Good morning. Please tell me your name. Did you say Hester? All right. In 2018 CT 2108, you're here because a capias was issued for your arrest for failing to appear for a pretrial conference on a charge of no valid driver's license. The bond authorized on that charge is $500. I'll appoint an attorney to represent you. In 20 CF 2636, you're here for violating your probation by leaving your county of residence without getting permission from probation and by being arrested for the criminal offense of offering to commit prostitution. At this time, there's no bond authorized on that warrant, and that was in Polk County. I'll appoint an attorney to represent you. Good luck, ma'am. And then the VOP is a CF. Yeah, it took me a minute with that.
Your Honor, can she hear the recommendations from the probation officer?
They don't all say that. Hold on, let me see if hers does.
And state doesn't have to file, or doesn't have to follow it.
Nor does the judge. Hold on, let me see if I can find it. So the probation officer is recommending that your probation be revoked, terminated, and that you be sentenced to a period of incarceration per the sentencing guidelines. Good morning. Please tell me your name.
Alexander Johnson.
You're here in 19 CF 1780 BO for a violation of probation. Hold on one second. The allegation is that you failed to live and remain at liberty without violating any new law, to wit, driving while license suspended, operating a motor vehicle without a license, and failing to register a motor vehicle. At this time, there's no bond, and I'll appoint an attorney to represent you. Good luck, sir. Thank you. That's 13 CF 11770, 16 CT 770, 12 CF 16012. I'm going to appoint the public defender to represent him.
We'll waive the appearance, Your Honor.
All right. There's no bond on either of the violations of probation, and on the KPS, the bond is $2,500. Go ahead. Please tell me your name. Good morning, ma'am. You're here in 20 MM 2998 for violating your probation. At this time, I'll appoint an attorney to represent you. There is no bond authorized on this warrant. The allegation is that you violated by failing to keep your appointments, possessing and consuming an unlawful substance, multiple substances, failing to enroll in the DUI counterattack school, failing to complete 50 hours of community service, failing to complete the recommended substance abuse treatment. At this time, there's no bond.
Your Honor, can Ms. Bellis be heard on the bond conditions?
There are no bond conditions.
I know, Your Honor.
You mean on bond? She wants to be heard on bond?
Yes, Your Honor.
Ma'am, you can say anything you want, but you understand that everything you say today is being recorded and can be used against you later?
I have 4 kids at home I have to take care of. I don't have any relatives. And then the only person I do have is my mother-in-law that just got into a car accident and broke her neck. So I just don't have anyone outside. Everyone else is in another country. So I don't have anyone outside of the home to help with anything. So I mean, I really have to take care of them. And you know what I mean? I don't know what to do.
Ma'am, Judge Bigney is the trial judge. She didn't authorize a bond on this. I think your attorney is going to need to file a motion in front of her. The allegations in this affidavit are pretty extensive.
Your Honor, may we enter a denial to get a court date?
Yes. The clerk will get it.
Status, December 8th at 9:30, courtroom 12C.
So that's your next court date unless your attorney can get you in front of Judge Bigney any sooner. Okay, so, sir, please tell me your name.
Carlos Saavedra Jr.
Good morning. You're here in 19 MM 7090. It looks like you saw Judge Bain yesterday,
Ma'am.
but he wanted you brought to court because he already appointed an attorney for you. And Mr. Brands, did you want to enter a denial so we can get him a court date?
Yes, Your Honor.
Division 50, VOP status, December 10th at 9 o'clock, courtroom 7C.
Good luck, sir. Yes, sir. Thank you.
Is that the courthouse?
I should take.
Good morning. Please tell me your name. Mr. Walker, you're here in 20 CT 4459 for violating your probation on a driving under the influence. The allegations are that you absconded from the jurisdiction, failed to pay, failed to complete the DUI counterattack school as directed, failed to complete the victim awareness program, failed to provide fingerprints. There's no bond authorized on this, and I'll appoint an attorney to represent you.
May we enter a denial, Your Honor?
Yes.
Division 61, VOP status, January 25th at 10:30, courtroom 6B.
Good luck, sir.
Was it 10:30? You said, I'm sorry, Madam Clerk?
I think that's what she said.
Yes.
All right, is the state ready for 33-day motions?
Yes, Judge.
Who do you have first?
Jeff Washington Jr., 21 MM 7526, should be granted. Notice of non-filing. Jaheim McLean, 21 MM 257 AE, denied and information was filed.
Good morning. Please tell me your name.
Good morning. My name is Marlon Securia.
Mr. Securia, you're here in 21 MM 7475, charged with petty theft with a prior conviction. Mr. Brantz, it's an arraignment and your office already represents him.
Yes, we'll enter a plea of not guilty, Your Honor.
Division 80, pretrial conference, December 20th at 9 o'clock, courtroom 9C.
That's your next court date, sir. Good luck.
Your Honor, is there a bond on Mr. Seguro's case?
I don't have that information because it's an arraignment. Do you have it?
Yes, it's a $1,000 bond.
Yes. Did you hear that? It's a $1,000 bond.
I had talked with my lawyer, and I talked to my public defender. And when he came and talked to me, he told me that I was supposed to be getting out on the 33rd day R&R.
What he was saying is that your attorney will file a motion for a release on your own recognizance if the state hasn't filed the charges within 33 days.
Correct. And today is my 33rd day. He said today on the 24th, I was supposed to be getting out on the R&R.
The case was filed 11/16.
So the state did file the charges. So the only way for you to be released is if you bond out. You'll have to post bond.
Okay, so they did file charges?
They did, yes, sir.
Okay, so I have to do my time and things?
No, you haven't pled or been found guilty. It just means that you have to post a bond to be released.
So I'm not getting out on R&R?
No, sir.
Okay.
But call your attorney because he can also file a bond motion at any time.
What's the bond motion?
So if your attorney files a motion asking the judge to reduce your bond from $1,000, they can do that. Good luck, sir.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
Good morning. If you could please connect to the headset.
There is contact, Your Honor.
Good morning, sir. Please tell me your name.
Mi nombre es Félix Figueroa, Santiago.
My name is Felix Figueroa Santiago.
You're here in 21 CF 14911. A warrant was issued for your arrest, charging you with lewd or lascivious molestation by a person over 18 years of age on a victim 12 to 15 years of age. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
Yes, Your Honor. Given that this is an offense that is sexual in nature as well as violent in nature, the state's just asking that you set a reasonable bond as he's otherwise entitled to it, as it is an F2. The alleged victim in this case was allegedly 15, I believe, when the offense occurred. So we just ask that you take all that into account. I believe Mr. Figueroa Santiago has a fairly limited criminal history. However, given the violent nature and the sexual nature of this case, so we just have to ask that you take that all into account.
Anything from the defense?
He is entitled to a reasonable bond, Your Honor.
I agree, he is. I reviewed the affidavit for the warrant. I also reviewed the information I have about his criminal history. The court is concerned that he has out-of-state criminal history, though I see that it is limited. At this time, sir, your bond is $50,000 on this charge. With special conditions, you can have no contact with the victim or the victim's immediate family members. Do you understand what no contact means?
Sí.
Yes.
You can have no contact with any minor child under the age of 18. You can't possess a weapon of any kind, firearm or ammunition. You can't be within 1,000 feet of the victim's residence or school. Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir. Good morning, sir. Please tell me your name.
Pedro Figas Peyot. Figas Peyot.
Pedro Figas Peyot.
Sir, you're here in 21 CF 15067, charged with possession of a controlled substance, tampering with physical evidence, and possession of drug paraphernalia. I'm going to appoint an attorney to represent you at this time.
Your Honor.
Mr. Brandt, did you have any arguments?
Yes, Your Honor. As to count 2, I believe there's enough PC to charge with attempt with tampering. I believe the evidence that was allegedly thrown away was recovered. And as to the possession charges, I know probable cause is a totality of the circumstances argument, but even though Mr. Ellis-Bellet noted that the substances may have been either heroin, fentanyl, or a combination of both, they were not field tested nor weighed. They were sent off to PLA. I'll just have you consider that and your determination. We don't know what they are at this point.
Thank you. What says the state?
In regards to the tampering, I don't believe it's the throwing away that is the issue, is that he had the syringe inserted into his left forearm. Law enforcement was telling him to stop inserting. He did not comply with law enforcement until he finished injecting himself. So that physical evidence, the drugs that were allegedly within that needle are gone and they're tampered with. Law enforcement cannot reobtain them. Therefore, I do believe there's PC as to count 2 that's currently charged. And in regards to possession of a controlled substance, again, counsel already made argument that is a totality of the circumstances argument. We have the victim's statement, or the defendant's statement regarding what potentially was in those bags, as well as the fact that he wasn't currently injecting himself. The state would contend that there's enough solely off that and based off all officer knowledge and experience.
I agree. I do think there's probable cause for both of the charges. And Jose said that the drugs were fentanyl or heroin. So I think there's enough for probable cause, perhaps not to get over any higher burden, but at least probable cause. At this time, sir, your bond is $1,000 on count 1, $150 on count 2, $100 on count 3. With special conditions, you can't possess or consume any controlled substance without a valid prescription. You can't have contact with any known drug dealers or the co-defendant in this case. And at this time, I'm revoking your bond in 21 CF 146, is that 70? Yes. Good luck, sir.
Pero tengo fianza o no?
Do I have a bond or not?
You have a bond on your new case, but I revoked your bond on your old case.
Pero entonces no puedo salir sin mi fido.
So if I pay this bond, I won't be able to go out, right?
You will not, that's correct.
We have to see a judge to do it.
Well, then I'll stay.
All right, good luck, sir.
Okay.
Good morning, sir. Please tell me your name.
José Luis Colón.
José Luis Colón.
You're here in 21 CF 15082, charged with burglary to an unoccupied structure and trespass on property after warning. I'm going to appoint an attorney to represent you in this case.
I'm sorry, Your Honor, what was it called?
Jose Colon, you got it?
Yeah. Your Honor, may I be heard on probable cause as to this case?
Yes.
With the burglary, I believe there has to be an offense committed therein, or an attempted offense. And I didn't see any. I mean, I saw enough PC for trespass, which he was charged with.
What says the state?
Your Honor, intent would be a question for the jury, and PC is an incredibly low standard. So for today, I believe the court defined PC for the burglary. We saw the defendant previously being trespassed and returning to the property on the 21st, and then re-returning on the 23rd.
Hold on one moment. Madam Interpreter, what is he saying?
I think that, yeah, I say that they say there's they break into the house like to steal. What I do? Okay. Ini, take it out.
Okay.
Okay.
Sorry, Your Honor.
That's okay. I just wanted to make sure. I wasn't sure if he was saying he couldn't hear or couldn't understand, and I wanted to make sure he could.
I believe he was doing the facts of the case now.
Right. I didn't know that at the time. I just wanted to make sure he could understand. All right, Ms. May, please continue.
The state's argument is that intent is a question for the jury. It's not something to be considered by the court today. The probable cause standard is incredibly low. State would contend that you can infer from him being trespassed on the 21st and then coming back to the property on the 23rd and having issues with law enforcement regarding remembering that he had a paper trespass and then entering the property without the right to be there. There's enough at this time for a burglary to an unoccupied structure. However, intent would be a question for the jury at a later time if this were to be found.
Your Honor,
Go ahead.
may I respond? The arrest affidavit even concludes by the officer that he's alluding to trespass charges or alluding to facts that would indicate trespass as opposed to burglary. I'll just have you see that as well. I don't think anything was taken or broken into.
So I read the affidavit. I appreciate the arguments from both sides. I think there's probable cause in part because the victim states that the defendant has come back multiple times after being trespassed to use drugs. So that could be the offense committed there within. Now, whether the state can get past probable cause, I'm not convinced. So
I understand, Your Honor, but as to the four corners, would it be, I don't believe drug use was involved in this particular case.
there is no, you're correct. There's nothing here that says they found syringes or watched him do drugs. But because within the four corners is the victim's statement that that is what he does there, I just think that's enough for probable cause. All right, sir.
I don't use drug. Yeah, I don't use drug. I usually go to church. So how come if a person go to the church, I'm gonna use I usually go Friday and Sunday, right? So how come I'm gonna use drug? You could even do my blood. You could check my blood.
We're not going to do that today. Let me give your attorney a moment to speak to you.
Yeah. Yeah.
First of all, you have to speak in Spanish. You have to say Spanish. Speak in Spanish. Also,
Okay.
don't talk about the facts of the case. We're not going into that right now.
So the only thing we're here for today is a determination of probable cause and to set your bond.
Okay.
It sounds like you think you have many reasonable defenses to these charges, and you might. I don't even know if the state will file these charges. That's up to the state of Florida. But for purposes of today, there is probable cause. So I'm going to stay your bond at $3,500 on count 1. I'll reduce count 2 to $100. With special conditions, you cannot return to 2650 Apopka Boulevard for any reason at all. Do you understand?
See.
Yes.
You cannot have contact with the victim or any witness in this case. You cannot possess a weapon, firearm, or ammunition. Sir, there's a phone number on that green piece of paper for you to call your attorney, and you can talk to them about the defenses you have to these charges. All right, good luck, sir. I think that's really confusing because everyone is in jail. I'd like to only address the in jail people right now. That's everyone.
Oh, did we do all the arraignments?
No, that's what she's saying is arraignments, but they say in jail because it's in jail arraignments. I'm just saying I think that's confusing because everyone we're addressing today is in jail. Otherwise, we're not addressing them. Good morning, sir. Please tell me your name.
Ricky Ray.
All right, so that's not who I have. Where's he?
It's an arraignment, Your Honor.
All right, he's 1, 2, 6 down. We'll go back to those. Let's address Mr. Ray because he's here. You're here in 21 MM 8173. Mr. Ray, you're charged with trespass and structure. Did the state have an offer?
No, Your Honor, it's a true victim case.
Oh, I see that. It was remanded. All right, Mr. Brantz, your office already represents him.
We'll enter a plea of not guilty, Your Honor.
Division 80 pretrial conference, December 20th at 9 o'clock, courtroom 9C.
That's your next court date, sir. Good luck. I don't know.
It's traffic. He has a dualis, a refusal, and a DUI.
That's the one you sent the written plea of not guilty email.
Okay, I don't have that one. All right.
I'll make it. I'll send an email today.
21 CT 7618. Mr. Brantz, your office already represents him.
Is this an arraignment?
It's a driving while license suspended, arraignment.
Yes, we'll waive the appearance and enter a plea of not guilty, Your Honor.
Division 63 pretrial conference, December 9th at 1 o'clock, courtroom 12C.
21 MM 7847. Mr. Brantz, your office represents him as well.
We'll waive the appearance and enter a plea of not guilty, Your Honor.
Division 50 pretrial conference, December 13th at 1:30, courtroom 7C.
21 MM 238. I'll find his refusal a willing waiver of his appearance today. Mr. Brantz, your office represents him. It's a trespass.
Yes, Your Honor. We'll You waive the appearance, and then we'll enter a plea of not guilty as well, Your Honor.
All right.
Division 63, pretrial conference, December 9th at 1 o'clock, courtroom 12C.
You don't want to try to bring him back tomorrow?
If you're,
The only reason I'm asking is I show he has 52 days credit on a trespass.
I know, can I approach on this, Your Honor?
Yes. Give us a moment.
Yeah, they won't do arraignments tomorrow.
I mean, can't I order it to be seen tomorrow? They're gonna say no? Well, hold on, let me hear about this. Yeah, he's ready to enter a plea to a misdemeanor trespass, and he's got 52 days, so by tomorrow he'll have 53. So can we just bring him back tomorrow? All right, let's put him on the docket for tomorrow. Can you guys just make notes about that for whoever's here tomorrow?
Yes, Your Honor.
You know what,
Since
I'll
it's a
do that for the
holiday,
judge too.
Arraignments aren't heard at all. So is this just put on the next arraignment docket?
No, I want him brought tomorrow. That's what I'm saying.
On like an add-on docket?
I don't understand that. He's here. We know where he is. Why can't we just bring him back? Is there a reason we can't? Put him on the docket for tomorrow without, yes. Okay. Who does Teresa need to say? Because I'll have my JA call and say, put this guy on the docket. Okay. She just left, so she won't have heard this. Let me send it to her. Hold on, everybody. All right. And I'm gonna take it back to give it to the judge who will be here tomorrow. I know who that is. Okay. Next. 21MM 7691. Mr. Brantz, your office represents him as well.
We'll waive the appearance and enter a plea of not guilty.
Division 61, pretrial conference, January 7th at 1:30, courtroom 6B.
21MM 8165. Mr. Brantz, your office represents him as well.
We'll waive the appearance and enter a plea of not guilty.
Division 83, pretrial conference, December 6th at 8:30, courtroom 6C.
Good morning, sir. Please tell me your name.
Demetrius Spires, ma'am.
21MM 246. You're here charged with 2 counts of battery. You're already represented by Mr. Brantz's office.
We'll enter a plea of not guilty, Your Honor.
Division 61, pretrial conference, January 7th at 1:30, courtroom 6B.
All right, good luck, sir. That's your next court date. Good morning, sir. Please tell me your name.
Onésimo Villarreaga, no contest.
All right, thank you, sir. You're here in 21 MM 777, charged with resisting an officer without violence and petty theft. There is probable cause. Was there an offer?
No, Your Honor.
Okay, hold on. What's the reason?
He has a current open petty theft, and I don't know the restitution for this case.
All right, at this time, sir, the state's not conveying an offer, and because of those reasons, I'm not going to accept an open plea to the bench, so you can't plead no contest today, but I'm going to appoint an attorney to represent you. Give me one moment, let me look at this one more time. At this time, I'll stay your bond at $500 on count 1. I'll reduce count 2 to $100. With special conditions, you can't return to the Publix at 1720 East Silver Star Road, and you can't have contact with any witness in this case. Do you understand?
Yes, ma'am.
All right, good luck, sir.
Thank you.
21 MM 8297. That's a trespass on property after warning, but he has that out on bond case. Give me one moment. I'm sorry, did you say he refused or it's behavior? Behavior. All right, I'm gonna appoint your office, Mr. Brantz. I need to review it one more time.
State did convey an offer. However, I was partially skeptical due to clenched his fist and started walking towards an aggressive manner. Law enforcement had to use taser to gain compliance, given that he is out on a violent offense.
Right.
I think they just pointed the taser at him, didn't they? I don't know if they used the taser.
They pointed it, they didn't deploy it.
Your Honor, I don't know what your action would be on the out on bond case, but would you consider a reset just because there is an offer?
Well, that's why I was reviewing the facts, because I needed to have in my head since he's not here. I would likely revoke that. I don't know if the judge who's here tomorrow would, but I might not, depending on what he says and what your argument is at the time. You know what because it's violent and it looked like he started to be violent, but he backed down, so I might revoke it, but I might not.
Your Honor, do you want a factual basis for the out on bond?
Yes.
On or about September 14th, 2021, the defendant approached the victim and asked how much were the shoes that he was holding. An argument ensued regarding the shoes. Allowed the defendant to demand the victim's shoes by brandishing a folding knife. Victim ultimately did not comply. The defendant left on a bicycle. All events occurred in Orange County, Florida.
I probably wouldn't revoke it. But it depends on his responses and what your argument is.
I'll leave my notes with the APD for tomorrow if you are willing to reset, Your Honor.
All right, I'll reset this one too. Good morning, please tell me your name.
Max Weber Germain.
Sir, you're here in 21 MM 8284, charged with trespass on property after warning. Was there an offer?
Yes, they conveyed an offer on adjudication, credit time served, and no return to Bonita Fountains.
Your Honor, I did have a chance to speak with Mr. Germain about the state's offer, as well as handed a plea form and went over those rights as part of a review of that. I have a moment to confer.
Yes. Ms. May, do you know what Bonita Fountains is?
I can double check, Your Honor.
I don't know what kind of property that is.
I believe it's an apartment, but I'll double check.
I believe he wishes to resolve that with a no contest plea today. As to the out on bond case, I would just, if you are inclined to take no action as a result of Mr. Germain's cooperation with the court and entering a plea today, I would just have you revoke and double the bond on that out on bond case.
But your client well, he's not your client. Actually, I'm going to appoint you in this case because of that out on bond case,
Yes, Your Honor.
because I want to make sure you take a moment to explain to him the court may still revoke it, even if he enters a plea.
Yes, Your Honor. A moment.
All right.
Yes, Your Honor. I believe Benita Fountains was an apartment building.
Okay.
I believe Mr. Germain understands the repercussions of that and still wishes to resolve the case today.
All right, sir, please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
All right, Mr. Germain, you had an opportunity to speak with your attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights? Do you have any questions for me about them? You understand we're not going to have a jury trial here today, and you're giving up your right to remain silent? You understand that? You understand that if you're on probation anywhere, this plea could violate that? I'm not saying you are, but I don't know if you are, so you understand if you are.
Just a moment, Your Honor.
Okay.
Sorry. Your Honor, I believe, can I approach on this?
Yes.
After conferring with our client, I would just have you set bond in the current case.
All right, Mr. Germain, at this time, I'll stay your bond at $500 with special conditions. You cannot return to Bonita Fountains for any reason at all. Do you understand that? You can't have contact with any witness in this case. You can't possess a weapon, firearm, or ammunition. Now, I see that you're out on bond in a petty theft, and I'm going to ask the state to give me some information about that charge.
Yes, Your Honor. In 21 MM 7435, the alleged date of incident was 10/20/2021, so approximately a month ago. State has not filed on that case to date yet. And in that case, it is alleged that on or about October 20th, 2021, the victim was at the fitness center working out at the same address, 5826 PGA Boulevard, when a male, later identified to be the defendant, asked her if he could borrow her cell phone to make a phone call. She said her cell phone and car keys were on the floor of the fitness center. He took her car keys from the floor instead of the cell phone. He proceeded to back away while holding the car keys. She attempted to stop the defendant from walking out of the fitness center with her keys, but he continued to leave. She grabbed the defendant by his shirt to stop him from leaving and ended tearing off part of his shirt. The defendant then ran away into the apartment complex area. All events occurred in Orange County, Florida.
And I'm sorry, at the beginning of the story, did you tell me, do they know each other?
I do not believe so, Your Honor. I believe the defendant asked a woman within the fitness center to use her phone and then instead took her car keys. I do not believe they know each other.
Okay.
She described.
And it was at Bonita Fountains?
It was, yes, it's at 5826 PJ Boulevard, which is the same address from this.
And when did that occur?
October 20th, 2021, approximately 10 hours, so 10 a.m.
At this time, I'm revoking your bond in that case, sir. Get in touch with your attorney, call the number on that green piece of paper. They're going to need to file a bond motion for you. Good luck, sir. Good morning, sir. Please tell me your name.
Michael Hendricks.
Mr. Hendricks, you're here in 21 MM 8302, charged with trespass on property after warning. There is probable cause. Was there an offer?
Yes, Your Honor, state did convey an offer of an adjudication, credit time served, no return. In regards, I'm sure you're looking at his last conviction, which was 10/14/2021. That was also a trespassing, however, it was a different location. And it originally came in as a felony with different charges. He ended up pleading to the trespass, and he had 50 days credit time served on that case.
What was the felony?
I believe it came in.
I'm assuming a burglary, but.
I believe so. I didn't write it down, but I can double check, Your Honor.
You know, they say you shouldn't make assumptions.
My internet's moving super slow.
It's really slow today.
Just in the interim, I did go over the offer from the state with Mr. Hendricks, as well as conveyed a plea form for him to review, and I believe he wishes to resolve today. For the record.
All right. Raise your right hand, please, sir.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
Mr. Hendricks, you had the opportunity to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest today. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them? You understand that if you're on probation anywhere, this plea could violate that?
Yes, ma'am.
You understand if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
Did you have a chance to read that plea form in front of you?
Yes.
All right, it further explains those rights. Do you have any questions about any of that?
No.
Anything else from the state?
No, Your Honor.
At this time, sir, how do you wish to plead to the charge of trespass on property after warning?
No contest.
Thank you, sir. I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 1 day that you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay those. I'll also order that you're not allowed to return to the hold on, I need the address.
It's the Quick Stop located at 2604 North Powers Drive.
All right, Mr. Hendricks, you can't go back there, you understand?
Yes, ma'am.
Good luck, sir. You have 30 days to appeal in writing.
Your Honor, would you be amenable to seeing Ms. Hudson and her sister at the same time? Is there any chance of them having contact as co-defendants during the proceedings, or?
Yes, you might want to bring them both in at the same time. All right, ma'am, at the podium, please tell me your name.
Bree Hudon. Heather Hudon.
Wait, what's your name?
Bree Hudon.
I have Hudson.
Yeah, they spelled our last name wrong.
But you are Bree and you are Heather?
Yes.
All right, so Bree, you're here in 21 MM 8289, charged with retail petty theft. And Heather, you're here charged with retail petty theft and 21 MM 8288. I do have you listed as co-defendants. There is probable cause. I'll appoint an attorney to represent each of you.
Your Honor, there were offers from the state, but I did meet with both Miss Hudson's and I believe they might be interested in a pretrial diversion program. I informed them that our office can't represent both of them, but the conflict counsel may also point them in the right direction as well as to pretrial diversion. I would just have you keep that in mind, Your Honor. I believe they both have very, if any, criminal history.
Well, I'm now trying to
I
check
see
that.
none. What?
I'm now trying to check that, Your Honor, given that they might have, the name might be incorrect.
Right, the names might be wrong.
Do you mind inquiring how they spell their last name?
I do see for Bree Hudon, she has criminal history out of New Jersey and New Hampshire. Last being in 2016 for disorderly conduct and shoplifting, which she was convicted of being guilty.
All right. For each of you, your bond is $250. Neither of you is allowed to have any contact with any witness in the case or Albert Parsons. You cannot return to the Walmart located at 3101 Princeton Street for any reason. I'm not going to order them not to have contact with each other.
Thank you, Your Honor.
They're sisters. All right, good luck. Yes. No, well, he's a co-defendant, but they're also co-defendants, so. Right, so if you put co-defendant, it means them. So you could put no contact with co-defendant except on each of them, put the other girl's name.
You only had history on Bree?
Yeah,
Out
I
of state?
didn't have a chance to look up the other one.
So I looked at Heather for Florida. I just see paternity dependency stuff, but I don't have access to NCIC information.
I think that's what's in the court file, and the state will have to fix that when you file it. Please tell me your name.
Delbert Parsons.
You're here in 21 MM 8290, charged with retail petty theft. There is probable cause. I'll appoint an attorney to represent you. Give me one moment. His criminal record is different. At this time, your bond is $500 with special conditions. You can have no contact with the co-defendants in this case or any witness. You cannot return to the Walmart located at 3101 West Princeton Street for any reason at all. Do you understand?
Ma'am.
Good luck, sir. See, don't you think that? Because I'm sorry, it's a little bit confusing, but there's 3 co-defendants. I think that's clear. Thank you. Oh. I haven't done it yet. Please tell me your name.
Andrew Ray, RUI.
You're here in 21 MM 8294, charged with retail petty theft. Was there an offer in this case?
No, Your Honor.
All right. There is probable cause. I'm appointing an attorney to represent you. Your bond is $500 with special conditions. You cannot return to the mall at Millennia for any reason. Do you understand?
Yes, ma'am.
You can't have contact with any victim or witness in this case.
S2 is out on bond case, Your Honor.
Go ahead.
I don't believe an information has been filed on that yet. He is out ROR after the 33rd day. Just have you keep that in mind, perhaps. If you take no action, just revoke and double, if you would. If you are inclined to do so, excuse me.
I'm inclined to revoke it. It's a violent offense. Does the state have that information?
Yes, Your Honor.
What are the facts and why haven't you filed?
So the out on bond, the 21 CF 13630, date of incident was 10/17/21, and is the reason state did not convey an offer on the current petty theft. The out on bond battered on a security officer was a security officer at a store. So that was the reason that the state did not convey an offer. And that out on bond case is alleged 10/17/21. Law enforcement encountered the victim holding the defendant on the ground in the interest of the business. Law enforcement detained the defendant and went to the business to view security footage. Upon reviewing security footage, law enforcement sees the defendant and victim speaking near the counter. The defendant then turns to leave and starts walking towards the door. The defendant then turned, removed his mask, and spit at the victim. The victim then rushes towards the defendant and pushes him out the door. The victim informs law enforcement that he works as security for the store. He was walking around the parking. The victim was walking around the parking lot and observed the defendant rolling a marijuana cigarette, or what he thought it to be a marijuana cigarette. The victim stated that he approached the defendant and told him to leave the property, as he was not allowed to smoke marijuana on the property. He was no longer wanted on the property. After that, the defendant left the property and returned to purchase food. When the victim saw the defendant at the register, he informed the cashier to cancel the defendant's order and to issue a refund, as he was not allowed to be in the store. The defendant then became verbally aggressive and threatened the victim. As he was leaving the store, he spit at the victim. At that time, the victim removed the defendant from the store, and the defendant turned and punched the victim in the face. The victim had a bloody nose when law enforcement arrived on scene.
That's enough.
All events occurred in Orange County, Florida.
Thank you. I'm revoking it, counselor. Mr. Ray, you need to call your attorney right away because I've revoked your bond and you're out on bond case. So even if you post the bond in the petty theft, you will not be able to be released today. Do you understand that?
Yes, ma'am. The charges on my other charge wasn't filed against me, and
They haven't filed it yet. I know. She told me that. But while you're out on bond or released on your own recognizance for committing a criminal offense, you can't be arrested for suspicion of committing a new criminal offense. That's what happened here, and they're very similar offenses. So I've revoked that bond. Call your attorney and ask them to file a bond motion.
which one? The one that I was already assigned, ma'am?
I'm sorry?
The one that was already signed, Samantha Lambert?
Yes.
Is that?
That's his PD for
Yes.
the battery.
I'm going to email her today.
So he'll email her, but you're going to call the number on that green piece of paper and ask to speak to her.
Okay.
Good luck, sir. Good morning.
Good morning.
Mr. Spruill?
Yes, ma'am.
You look really familiar to me, sir.
Yes, ma'am. I've been here for open container.
I know, I keep seeing you.
I went in the store to eat. That's all I did.
Well, hold on. I don't want you to talk about it yet. First, let me tell you why you're here. It's 21 MM 8296, and you're here charged with trespass on property, trespass and structure. Was there an offer?
Yes, Your Honor, state made an offer of an adjudication, credit time served, and no return to the McDonald's located at 830 South Orange Blossom Trail.
I did have a chance to convey that offer to Ms. Sprullo, and we spoke about the The rights to be waived, I also give him a plea form to review. I believe he wishes to resolve today.
Is that what you want to do today, sir? All right, raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Thank you.
All right, Mr. Spruill, I think I saw you just last month.
Yes.
And we talked about the rights you're giving up if you enter a plea of guilty or no contest.
Yes, ma'am.
It's those same rights. Do you remember them?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
All right, so you had an opportunity to speak to an attorney before court.
Yes.
He explained to you, I'm sure, that if you're on probation anywhere, this plea will violate it.
Yes.
And if you're not a U.S. citizen, you can be deported.
Yes.
Before we do this, can I have the attorney's approach? Just a minute, sir. I'm going to give your attorney a moment to speak with you. You know where he is? Teresa's doing an add-on docket because I told her we've got to do that. So hopefully. Between all of that.
Your Honor, as to the offer from the state, may we plea to the bench on an amended offer of adjudication, 3 days in OCJ, and no return to the location? With credit
Yes,
time,
I'll sentence him to that.
with credit time served for the 2 that he's
Yes.
already been here.
I'll do that. Mr. Spruill, we just talked about all the rights that you'd be giving up. At this time, how do you wish to plead a trespass in structure?
Guilty.
All right, I'll accept your plea of guilty. I find it's freely and voluntarily made. I'll adjudicate you guilty. I'll order that you serve 3 days in jail. I'll give you credit for the 2 days that you've served. Sir, I have to order you not to go back to that McDonald's. You understand that?
Yes, ma'am.
It's at 830 South Orange Blossom Trail. You can't have contact with any witness in this case.
Yes, ma'am.
I have to order that you pay court costs. I'll reduce those to a lien at this time. All right, sir, good luck. You have 30 days to appeal in writing.
Oh, yes, ma'am.
I hope you have a good Thanksgiving.
Thank you, ma'am. Yeah.
Yes, sir. Good afternoon, sir. Please tell me your name.
It is Terrell.
All right, Mr. Terrell, you're here in 21 MM 8301, charged with trespass on property after warning. There is probable cause. Was there an offer?
Yes, Your Honor, State made an offer of an adjudication, credit time served, no return. His recent trespass was a different location.
I did convey that offer to Mr. Terrell, Your Honor, and we went over the plea form to review, and I believe he wishes to resolve today.
Please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Thank you.
All right. You were able to speak with an attorney before court about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
Did you have an opportunity to review that form in front of you?
Yes, ma'am.
All right. It further explains those rights to you. Do you have any questions about the form?
No, ma'am.
All right. You understand that if you're on probation anywhere, this plea could violate that.
Yes, ma'am.
You understand if you're not a U.S. citizen, you could be deported.
Yes, ma'am.
Understanding all of that, at this time, how do you wish to plead a trespass on property after warning?
No contest.
I'll accept your plea, sir. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 1 day that you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. And I'm going to order you're not allowed to return to the quick stop at 2604 North Powers Drive. Do you understand?
Yes, ma'am.
All right, good luck, sir. You have 30 days to appeal in writing. Please tell me your name.
Burton Yang.
You're here in 21 MM 8295, charged with trespass on property after warning. And you have a violation of probation out of Seminole County in 2002772. Was there an offer on the trespass?
There was not, Your Honor, due to VOP.
All right. At this time, sir, I'm going to appoint an attorney to represent you. Give me one moment. Your bond is $500. You can't return to Universal Studios for any reason. You can't have contact with any witness in this case. And we'll notify Seminole County that you're here.
Your Honor.
Yes.
I believe his vehicle is still at the parking lot at Universal. Is he able to do a one-time return for?
Yes, I'll
property?
allow a one-time return to get your vehicle. Yes, sir. Good luck.
Did we skip Mr. White?
Yeah. He was before Yang,
Mr. White?
but, right, Tyrese White. Sir, please tell me your name. You're here in 21 MO 1382, charged with disorderly conduct. There is probable cause. Was there an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer withhold credit time served.
I did have a chance, Your Honor, to speak with Mr. Failer about the state's offer, as well as conveyed a plea form to review. I believe he wishes to resolve today.
Please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
All right, sir, you had the opportunity to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
You understand if you're on probation anywhere, this plea could violate that?
Yes, but I ain't on probation.
I believe you, but I have to ask everyone, because if you are and I don't know it, I just want to make sure you understand that.
Yeah, I understand.
All right, sir, you understand if you're not a U.S. citizen, you can be deported. At this time, how do you wish to plead to the charge of disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay those. Good luck, sir. You have 30 days to appeal in writing.
Can I ask you a question?
Yes, sir.
Where do I get to pay the fine and stuff? Cause I ain't really from here.
All right, so I didn't levy any fine against you. It's just court costs because I'm required to impose those. So what you can do is you can go to the courthouse, at the clerk's office and make payments, or they can pay online, right? You can also make payments online,
Okay,
but whatever's easiest for you.
okay.
And I'm giving you a year, that's the longest I can give you.
Okay, thank you, ma'am.
Yes, sir, good luck. Have a nice Thanksgiving.
You too.
I'm gonna give you the sheet. Where the courthouse is downtown, it's the big tall building.
No.
If you go down to Colonial, there's like a shelter down by Colonial. And then like right down the road is a real tall building, the courthouse. Go there.
I don't have that one. Oh, what happened to Taiwan Thomas? 21 MM 8291. Okay. Good afternoon. Please tell me your name.
Andrea Ferguson.
Ma'am, you're here in 21 MO 1383, charged with disorderly conduct. There is probable cause. Was there an offer?
Yes, Your Honor. I've been authorized on the city's behalf to offer a withhold credit time served.
Your Honor, I did have a chance to speak with Ms. Ferguson. We've spoken before, and I conveyed the offer as well as a plea form to review. I believe she wishes to resolve, but today, for the record, I know we've had a case with a bagel. Today it was a taco.
I know. Listen, if there was anything I could do, I would, but there is not.
I understand, Your Honor. I believe she wishes to resolve with a plea of no contest, Your Honor.
Please raise your right hand, ma'am.
This one right here.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
All right. You had an opportunity to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes. Yes.
I feel like I saw you recently. You've been in this courtroom recently, right?
Do you remember her?
Do you remember me? I remember you. We talked about the rights you'd be giving up.
That was a long time ago.
I don't think it was that long ago, but maybe. But at any rate, I remember you, Ms. Ferguson. Do you have any questions for me about the rights you're giving up? You understand you're giving up your right to a jury trial, your right to remain silent, your right to force the state to prove all the charges against you. We're not going to have a jury trial.
That's like if we went all the way, we did the trial, and you could testify that you're not guilty.
Right.
You would have a jury of people to see if you were guilty or not. We're not doing that because we're just resolving it today. Does that make sense?
Yes. Thank you.
So you understand that, right? We're not going to call any witnesses,
Yes.
and that's what you want to do.
Yes, ma'am.
So you're going to enter a plea today, and I'm going to sentence you today.
Okay.
Is that what you want?
Yeah.
All right, you understand if you're on probation anywhere, this plea could violate that.
Yeah.
If you're not a U.S. citizen, you could be deported.
Yes.
At this time, ma'am, how do you wish to plead to the charge of disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the
2 days.
2 days you've been in custody. Ma'am, I have to order that you pay court costs. I'll give you a year to pay those.
Yes.
Good luck, ma'am. You have 30 days to appeal in writing. I hope you have a nice Thanksgiving. Yes, ma'am.
What if I won't be able to pay it off because I'm homeless?
I'll reduce it to a lien. I'm going to reduce it to a lien.
A what? Okay. Thank you.
So what that means is later on, if you ever wanted to buy a house or something, there's still going to be a lien, or if you're going to get a driver's license, there's a lien on you, but you don't have to pay it right now.
All right. Thank you.
Good luck, ma'am.
Your Honor, may I approach?
Yes. Thank you. Oh, that's all of them. Please tell me your name.
Cameron Eland, ma'am.
You're here in 21 CT 1286 because a capias was issued for your arrest for failing to appear for arraignment on a charge of driving while license suspended. The bond authorized on that capias is $4,000. I'll appoint an attorney to represent you. I show that he's a violent felony offender of special concern.
Yeah, that's what I don't understand where that came from. 'Cause I
It
tried,
looks like you were released or, oh, is he on probation right now?
yes,
Oh, it's because you're on probation for a violent offense.
yes, I just got released, reinstated last Thursday. That's why I was failure to appear on this, because I was incarcerated in Duval for the last 80 days. And that's why I'm glad. Thank you for saying something, because I've been incarcerated since September 4th when they came to get me on the first.
In the Duval County Jail?
I live in St. Cloud. They came and got me in St. Cloud for just driving on suspended license. And I bonded out with $200 bond there. But then I had a violation of probation in Duval. They came and got me on the 11th. I've been there ever since Thursday. That's how I missed this court date on 10/26. I believe it was 10/26. I was supposed to be.
Okay, but were you in the Duval County Jail?
Yes, ma'am. And they reinstated it Thursday. I was waiting to be released, and they said I had to come here for this. I tried to bond out, and they're saying that, and I don't have any violent crimes. I just don't understand how it came up.
Well, so what happened is you failed to appear in front of Judge Dubois after being ordered to do so. So he issued a capias for your arrest, and the bond is $4,000. I can't change the bond on a capias.
I understand that.
But
I can bond out, but what they're saying is the hold for the VFO.
VFOSC?
Yeah, I'm not understanding.
the violent felony offender of special concern.
Yes, ma'am. That's what.
So if he bonds out, is he going to be released?
Yeah, he can bond out. It's been lifted
Okay, so that hold has been lifted.
because it's just an FTA warrant.
You sure? Call it.
I closed it myself.
Because the only other thing I was going to say, Mr. Brantz, is if you want to bring him back at the end of the docket, I can call Judge Dubois, but I need proof that he was, it's not that I don't believe you, but I need proof that he was in the Duval County Jail because I can't change a capias, but Judge Dubois could change this today if we have that proof.
Yes, Your Honor.
Do you want to bring him back at the end? See if we can find out if there's a way to prove he was in the Duval County Jail?
Yes, a moment to confer, Your Honor.
Okay. I just don't know if the jail would have a record of that.
And
I feel like DOC does, but I don't know that county jails have a record of when people were released, once they're released. I mean, I'm sure they have a record. Whether we can access it on the internet is a completely different thing. That's what I'm saying.
Ms. Davis, is that something you can, because he says he might have proof in his property, but I don't know if it's something easy that we could find out. Okay.
What do you mean you have proof in your property?
The sheet. Well, I had the sheet. I think they still have, because I got conditions of when they reinstated my probation.
Mm-hmm.
I'm supposed to be going to. I live in St. Cloud. I was going to the treatment center as soon as I got released.
But you have that in your property here at the jail?
Yes, ma'am. It should be in my property because they just transported me from Duval. They picked me up from Duval yesterday afternoon and brought me here.
That was like in your pocket or something, so you have it with you?
No, ma'am. It's in my property though.
Okay. Is there a way for someone in your office to start working on that?
Could the property still be in Duval?
No, it's here.
Oh, it's here? Okay.
He said they picked him up here.
Oh, I thought maybe he had property in Duval and then they just took him. I misunderstood.
Yes, sir. They brought everything.
So, yeah, let's try to do that.
All right, we're going to bring him back at the end of the docket. There may be nothing I can do, sir, but we'll at least see.
Okay, thank you.
Okay. Good afternoon, sir. Please tell me your name. You're here in 21 CT 111 because a capias was issued for your arrest for failing to appear on a charge of driving while license suspended. The bond authorized on that is $1,000. I'll appoint an attorney to represent you. Does he have a hold out of another county?
He does.
And you have a hold out of Highlands County. Good luck, sir.
I already know. I already posted bond here. Just waiting on me.
Oh, okay, good luck. Please tell me your name.
My name is Calvin Pugh.
Sir, you're here in 21 MM 8299, charged with resisting an officer without violence. 21 CT 1072, charged with driving while license suspended, a subsequent offense. And you have a civil contempt of court in a DR case, 083031. I'm going to appoint an attorney to represent you. Hold on one moment. There is probable cause. Your bond is $500 on the resisting without violence, $100 on the driving while license suspended, and the contempt of court, it's $2,000. All right, good luck, sir. It's on there. Right. Good afternoon. Please tell me your name.
Good morning, Jarvis Thompson.
All right, Mr. Thompson, you're here in 21 CT 45. A capias was issued for your arrest for failing to appear on a charge of driving while license suspended. There's no bond authorized on that capias, and I'll appoint an attorney to represent you. You're also here for a violation of probation out of Osceola County in 20 CT 2920. There's no bond on that. I'll appoint an attorney to represent you. We'll notify them that you're here.
Your Honor, I believe was he seen on that yesterday?
He was just here for the traffic case.
Okay, so he's already seen on that. I don't know why they're all listed then. That's really nothing I can do about that. All right. Good luck, sir.
I'm supposed to turn myself.
Yes, that's it. Yes, sir. Good luck. Please tell me your name.
Alan Bjorn.
Good afternoon. You're here in 21 CF 15083, charged with grand theft of a motor vehicle. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $2,500 with special conditions. You can have no contact with any victim or witness in the case. You can't return to Wally Park Airport parking at 5601 Butler National Drive for any reason.
That was $1,000, Your Honor.
It's $2,500.
Okay, I'm sorry.
Are there any other conditions the state would request?
No, Your Honor.
At this time, I'm revoking your bond in 21 CF 13311. Good luck, sir.
Send an email.
Please tell me your name.
Orlando Candelaria.
Good afternoon, sir. You're here in 21 CF 15088, charged with burglary of an occupied structure and grand theft. There is probable cause. I'll appoint an attorney to represent you. Your bond is $5,000 on count 1, $150 on count 2. With special conditions, you can have no contact with any victim or witness in this case. You can't return to, just a moment, you can't return to 9899 International Drive for any reason. Yes, sir, did you have a question?
Yes, the first day I came, Your Honor, they had no info. They reset me again, and they had no info the second day. I was wondering, is it possible to get pretrial? Because I can't afford a bond right now. Last time, I had one trial on pretrial. I don't have no reason to run or anything like that. I just need to take care of some things, and I don't have the means right now.
You don't qualify for pretrial release?
I'm actually a worker at the convention center. Both days security let me through. Okay. Yes, sir.
I believe he still would request PTR or, in the alternative, a lower monetary bond.
All right, hold on one moment. Sir, you don't qualify for pretrial release, so I can't place you on that.
Is it possible to get RR? Because last time it was the
No.
same thing. They tried to name this a burglary on another occasion of another place. The sheriff has just been giving me a bad name. He even says on the affidavit, if you read it, he said, you know, I wanted to give him a simple possession charge, but we don't have that statute. They really didn't know what to do, Your Honor. If you RR me, I have no problem going to court.
Sir, I'm looking at your record and the facts in the affidavit, and I'm not going to release you on your own recognizance at this time.
Your Honor, he's here for, this is an add-on charge. He's also here for 2 very similar offenses. The 13588 case where Berg occupied and the 12969 case where Berg structure grand theft.
I don't have that he's here on those today.
They're not heard today, but he was in custody on this.
Right.
This is an add-on charge.
Right. So I'm not going to release you on your own recognizance at this time. But what you can do is call the number on that green piece of paper and ask your attorney to file a bond motion in front of the trial judge. They can change the bond at any time.
Well, I spoke to him, and yesterday he said the state did not stipulate whether a release or not for our pretrial release, because he knows me. You can call him now, and he knows that I show up. I have no issues. Like when last time they put me on PTR, I won trial, Your Honor, and I was looking at 20 years for the same type of thing. They try to give me a burglary for no reason. They just been giving me a bad name. And I also have a lawsuit right now with Universal and Avis because of that. It's just the sheriff's office, I don't try to give them a bad name. I know they mean well, but somehow they trying to give me this burglary. Even in the affidavit, known burglar, I've never been guilty for burglary. I've never took a plea for that. That's insane. They just don't know what's going on. And I know that I'm for sure can take care of this. It's just both, it's not something that they're thinking, I'm sure, Your Honor.
Well, what I have as your criminal history, the most recent conviction was July 8th of this year for petty theft with 2 prior convictions. I have in Florida.
I pled no contest to that, Your Honor, because I didn't want to battle that.
Okay, just let me tell you what I'm looking
Yes,
at.
ma'am.
Listen, all we're here for today is probable cause and bond. I'm telling you why I'm not going to release you on your own recognizance. The Florida history that I have on you is that you've been convicted of
But why are they
burglary at
raising
least
my
3
bond?
times, grand theft twice, violating probation, petty theft 5 times.
Why are they raising my bond, though, Your Honor? It was first it was ROR, then it went to 4,100. Now it's to 5,000 and one. Like I don't. Like,
Sir, I have not raised your bond.
not you, but like somehow this has just been all off. It's not on point. something is just, it's just not right here.
I don't know. I can tell you I'm reading the affidavit and I have the limited information about your criminal history. So based on the information that's in the affidavit,
Okay,
there
so-
is probable cause.
So what am I being charged with at this moment?
You were arrested for burglary of an occupied structure and grand theft.
Okay.
Those are the charges for which I have found probable cause.
And
Now,
is that all?
whether
holding
the
me?
state of Florida files those charges, I don't know.
Is that all that's holding me right now?
No, that's this one case. You have 2 other cases.
What's the other 2 cases?
Burglary of an occupied structure, burglary of a structure, and grand theft.
So I have 3 now?
Yes, you have 3 separate
So
cases.
this is a new case
Right.
that I have not been fingerprinted for or anything like that?
I don't know if you've been fingerprinted or not. But this is the first time you're seeing a judge on this case.
So this is an actual, not the same case, something different, or they making a mistake? Because my lawyer said all I have is the one burglary that wasn't supposed to be filed on, and he said the worst I was looking at is a grand larceny or petty larceny, because I found an iPad, returned it to the sheriff. There's no damages, nothing was placed in NCICS. The sheriff didn't, you know what I mean? I don't.
No, sir, this is on or about September 22nd at the Orange County Convention Center. A laptop was stolen from a display. That's the facts of this case.
Okay.
So you're gonna need to call your attorney. I don't know about your other cases. I don't have those. But there is probable cause for this case.
Okay. Thank you, Your Honor.
Yes, sir. Good luck. Good afternoon. Please tell me your name.
Good afternoon, Elliot Anthony Castillo Jr.
You're here in 21 CF 15052, charged with fleeing or attempting to elude law enforcement with lights and sirens activated, and grand theft of a motor vehicle, and 21 CF 15053, driving while license revoked as a habitual offender. At this time, I'm appointing an attorney to represent you in both of these cases. There is probable cause. Your bond on count 1 is $15,000. Count 2 is $150,000. Your bond on the driving while license suspended is $5,000. You can not drive in Florida without a valid Florida license. You can have no contact with any victim or witness. That's in the grand theft. Good luck, sir.
Just a moment, Your Honor, to confirm.
Yes. Thank you. 21 CF 15073. I'm going to appoint your office, Mr. Brantz.
We'll waive the appearance, Your Honor.
There is probable cause. Does the state wish to be heard on bond?
Yes, Your Honor. Mr. Coleman is entitled to bond. This is an F1, not a punishable by life offense. Let's say we just have you take into account that it is alleged that Mr. Coleman is a registered sex offender from the state of New York, and he's yet to register as a sex offender in the state of Florida. That charge may be coming at a later time or when this is filed, as he just received a Florida driver's license on 6/3/21 and did not register at that time, which would have been the appropriate time to do so. In addition to the allegations within this affidavit, as they are sexual in nature, state would just ask for a reasonable bond given his history and given that he is a registered sex offender.
Any response from the defense, Mr. Brantz?
He is entitled to a reasonable bond under the circumstances, Your Honor.
I reviewed the affidavit. There is probable cause. I see that he is a registered sex offender.
Yes, Your Honor. And state's also concerned regarding his community ties, as it appears that he recently got to Florida, as he just obtained that driver's license, appears in June.
You know, the court is concerned about that. He's a violent felony offender of special concern, possibly. His most recent conviction that I show was out of state in 2016 for a sex act on a person incapable of consent. I see that he has multiple arrests out of state. However, he is entitled to bond. At this time, his bond is $100,000. He can have no contact with the victim or any witness in this case. He can't possess a weapon, firearm, or ammunition. He can't be within 1,000 feet of the victim's residence or place of employment. He must comply with all sex offender reporting requirements. Are there any other conditions the state would request?
No, Your Honor.
Good afternoon, sir. Please tell me your name.
Tony Harrison.
Mr. Harrison, you're here in 21 CF 14832.
Can I say something, Your Honor?
Hold on one second. Let me tell you why you're here. You can say anything you want, but everything you say here is being recorded and can be used against you later. Do you understand that?
Ma'am.
All right, so 14832 is dealing in stolen property, grand theft, and receiving money from a pawnbroker using false verification of ownership. A warrant was signed by another judge, so probable cause has already been found. And then in 21 CF 13943, a warrant was issued in that case as well. Again, probable cause has already been found. And it looks like the state filed that information in that case, charging you with grand theft and battery. I'm going to appoint attorneys to represent you in both of your cases. Do you still wish to say something, Mr. Harrison?
I don't believe he has anything to say at the moment, but let me check on while you continue with the bond conditions, Your Honor.
All right, in 14832, your bond is $1,000 on count 1, $150 on count 2, and $100 on count 3. You can have no contact with any victim or witness in this case, and you can't return to the scene or the pawn shop. What was the name of the pawn shop? Sorry, I wasn't asking you. Sorry, I'm asking the state.
1 second, Your Honor.
I got out of that affidavit.
I did too.
I'm sorry.
I pulled it up earlier to look up date of incident. I didn't write that down to 1 second. 14832. It is. Yeah, I'm on the clerk's site, but my internet will not let me open the affidavit again.
All right, hold on a minute. Let me go back to that affidavit.
Sure.
Eco ATM located at 5734 South Orange Blossom Trail. You can't go back there, do you understand?
Yes, ma'am.
All right. In 13943, your bond is $1,500 on count 1, $500 on count 2. You can have no contact with any victim or witness in that case. You can't return to the scene for any reason. You can't possess any weapons, firearms, or ammunition. Any other conditions the state would request?
No, Your Honor.
Did you get the date for?
Yes, Your Honor, I do have both dates. For his out on bond, the date of incident was 6/27/21. He bonded 6/28/21. Therefore, he was only out on bond in the 13943 case. So he's out on bond when he picked up the 13943, not the 14832.
32, yeah, that one was in June.
It was 6/5. This one he bonded 6/28. So
Okay.
And Your Honor, maybe you heard on that out on bond case?
Yes.
It's been since June 28th, like state mentioned, as well as our client's been making good faith efforts to call in to check on any court dates in that case, and there have been none. I don't think anything's even set for a hearing, to my knowledge. Also, the current charges are not drug-related, so I would just have you consider all that, and if you, in your discretion, if you would revoke and double, I believe that would be sufficient.
I'm not inclined to do that at this time. Sir, I'm revoking your bond in 21 CF 7562. Good luck.
Motion.
Just for the record, Mr. Harrison has an extensive history. I show that his last conviction was in 2018 for violating probation on a burglary of a dwelling. He was just released off supervision or out of DOC in 2020. He has 2 prior failures to appear and several other violations of probation, so I'm revoking it. Good afternoon. Please tell me your name. Mr. Judy, you're here in 21 CF 15095, charged with 2 counts of battery on law enforcement officer, resisting with violence, 2 counts of assault on law enforcement officer, resisting with violence, resisting without violence, trespass and occupied structure. I'm going to appoint an attorney to represent you in this case. Do you have an argument?
Well, no, the duplicative charge of with and without violence, it shouldn't be one or the other. I believe it would be enough PC for with. I don't know if there was a separate incidence without.
Your Honor, not following commands is enough for without. State can file both, and he can be convicted of both. It's not a double jeopardy issue, and it's definitely not a PC or IA issue. He could not be, if defense counsel was arguing 2 counts of resisting without, that is a double jeopardy issue because we couldn't charge that for 2 different officers, but given that it is with and one without, we don't have issues here today.
And I think because the battery is and the assaults are on different officers, I think there is probable cause.
I understand that, Your Honor, just the resisting charges.
So I have found probable cause. I'll stay your bond at $2,500 on count 1, $150 on 2 and 3, and $100 on 4, 5, 6, and 7. With special conditions, you can have no contact with any victim or witness in this case. You can't possess a weapon of any kind, firearm, or ammunition. You can't go back to the Orange County Public Library. Do you understand, sir? You have to answer out loud. All right, good luck, sir. Good afternoon. Please tell me your name. Sir, you're here in 2020 CF 8745, charged with introducing contraband into a state facility. A capias was issued for your arrest. I'll appoint an attorney to represent you. Your bond is $1,000. You can't possess or consume any controlled substance without a valid prescription or any weapons, firearms, or ammunition. Do you understand? Good luck, sir. Good afternoon. Please tell me your name.
Lyndon Malcolm.
Sir, you're here in 21 CF 15064, charged with driving while license revoked as a habitual offender and no motor vehicle registration. There is probable cause. I'll appoint an attorney to represent you in this case. Your bond is $2,500. You can't drive without a valid Florida license. Do you understand that?
Yes.
Your Honor, is there bond on the registration?
Oh, $100. Sorry. Thank you. I show that he's out on bond for driving while license suspended. But it's a felony because it's a CF.
Yes, Your Honor, we've ended up filing a misdemeanor dualis in M2. To correct the case number on that's 21 CT 915.
Do you have his driving history or driving record? What's the reason for the revocation?
I don't have it uploaded to case management. It's most likely in the fiscal file. One second. I don't see his driving history on the clerk's site either, Your Honor. I see that it was ordered by the state, but it's most likely a paper in the file.
I'm going to take no action on that case. Good luck, sir. Just a moment. Good afternoon, sir. Please tell me your name.
Repeat Sean Mathis.
All right, Mr. Mathis, you're here for a couple of cases. In 21 CF 15085, you're here charged with possession of MDMA and possession of cocaine. I'm going to appoint an attorney to represent you in this case. There is probable cause. Your bond is $1,000 on count 1, $150 on count 2. With special conditions, you can't have contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. Do you understand? And then in 21 CF 14418, a warrant was issued for your arrest, charging you with possession of MDMA. Another judge has already found probable cause in that case. I'll appoint an attorney to represent you. Your bond is $1,000 with the same conditions. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. I show that he's out on bond in 2 cases. Both are controlled substances. One is sale and delivery of cocaine and one is possession. Hold on one second.
Yes, Your Honor. In the 8506 case, It came in with meth or MDMA and cocaine. We ended up filing the cocaine on 8506. And in 8914, we did file sale and delivery of cocaine, F2.
Mr. Brands, I'm inclined to revoke those. I also show that his most recent failure to appear was in July of this year.
Yes, Your Honor.
All right, Mr. Mathis, I'm revoking your bonds in those two cases, so your attorney's going to have to file a motion in front of your trial judge. Good luck, sir. Good afternoon. Please tell me your name,
Martin.
your full name.
Martin L. Charles Palmetier Jr.
Sir, you're here in 21 CF 14874 because a warrant was issued for your arrest for failing to comply with your sex offender reporting requirements. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you.
May I say that I was still residing at that residence until the 23rd, which has been updated in my sex offender stuff. So the warrant is kind of invalid when I still stayed there from where it says I moved out October 6th until I moved out this Monday.
So the affidavit for the warrant says that on November 17th of 2021, law enforcement conducted an address verification for Martin Charles Palmetier.
Yes, and I was at work at 7 a.m.
Just a moment, Your Honor.
All right, sir. Another judge has already found probable cause for this charge. It sounds like you think you have some defenses, so I'll just encourage you to get in contact with your attorney right away. Your bond is $15,000. You must comply with all sex offender reporting requirements while out on bond. Do you understand? All right, good luck, sir. Good afternoon. Please tell me your name.
Quavers Preston.
Mr. Preston, you're here in 21 CF 15065, charged with burglary of an occupied dwelling and resisting an officer without violence.
Your Honor.
I'm going to appoint an attorney to represent you. Yes, Mr. Brands.
If I may re-raise my previous legal argument on the burglary. As with the four corners of the affidavit, I don't believe there was an intent to commit an offense therein. I don't believe anything was taken or destroyed or broken in any way.
Other than the window? Isn't this the one where the window was broken?
I thought it was an open patio door.
No, it was.
Hold on. Maybe I'm remembering a different case. Let me review this affidavit. pliers were found near the window.
The victim stated that she heard a piece of wood lean. She stated that a piece of wood leans against the door and she heard it fall as if someone opened the screen door. The screen door was unlocked. The victim stated that she heard the sliding glass door to the residence, which is located in the screen room, jiggle, but the door was locked.
All right, so what is your argument, Mr. Brantz?
I found enough probable cause for trespass, but as to the burglary charge, I don't think. Under the totality of the circumstances, there would be enough to find probable cause for a burglary.
What says the state? Oh, sorry, I'm sorry, I thought you were done.
I was just gonna add that, especially with the point that I made about the offense therein, if there was no intent to commit offense therein, or evidence that showed that there was an offense taking place.
What says the state?
Your Honor, state would argue that for the burglary, it was outside the residence, as it appears also inside the residence, I believe, as there were footprints located also within the tub. The footprints matched that of the defendant. It was 8:08 a.m. and law enforcement saw the defendant fleeing at a high rate of speed away from the location, and then also took flight into a McDonald's also to lure away law enforcement. He did allegedly leave a pair of needle-nose pliers were placed into the window frame. It's the intent to commit an offense herein. State would contend that flight from the area, as well as footprints all along the bathroom area, inside the tub, streaks down the wall, and the needle-nose pliers would all be an indication that there was an intent to commit an offense therein, in addition to running and biking away from the scene at a high rate of speed away from law enforcement.
Your Honor, if I may respond.
Go ahead.
As to the needle-nose pliers, I don't know if there were facts that the owner said that that was theirs or were not theirs. They could have just been in the house. It could be the owner's.
They could be.
I don't believe that's a reasonable reading of the affidavit, but.
I reviewed the affidavit. I do think there's probable cause for the charge of burglary of a dwelling. I think that's an extremely low bond for this charge. However, I'll stay it based on defense counsel's arguments. Sir, your bond is $5,000 on count one, $100 on count two. With special conditions, you can't return to the scene for any reason. Do you understand?
Yes, ma'am.
You can't have any contact with the victim or any witness in this case. You can't possess a weapon, a firearm, or ammunition. Any other conditions the state would request?
No, Your Honor.
Good luck, sir. Good afternoon, sir. Please tell me your name.
Alvin Rivera.
Mr. Rivera, you're here in 21 CF 15089, charged with trafficking in oxycodone greater than 4, less than 14 grams. At this time, I'll appoint an attorney to represent you. Did you have an argument, Mr. Brantz?
Not to the charge, but were the 6.32 grams, was that including the 10 pills or also including the caps?
No, it says without the packaging, it weighed 6.32 grams.
Well, there were no packaging. The items were found loose within his pocket.
And that came out to 6.3?
Apparently.
No argument this time, Your Honor.
All right, I didn't think so. I read the affidavit, it said that, so I think that does meet the requirement.
Yes, Your Honor.
Sir, your bond is $100,000 with special conditions. You can't have contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. Do you understand? Good afternoon, sir. Please tell me your name.
My name is Gabriel Rodriguez, Your Honor.
You're here in 21 CF 15071, charged with attempted robbery with a weapon and a mask, robbery with a weapon with a mask, possession of cocaine, and possession of drug paraphernalia. At this time, I'm going to appoint an attorney to represent you. Mr. Brantz, did you have any arguments in this case?
The only argument I thought to make was in the era of COVID, a lot of people are wearing masks, so.
I was waiting for the day that argument comes.
I think we've had a case before, but I don't know if the appeals courts have heard anything or sent down any guidance, but that would have been my argument had I had a stronger research behind it, but I do not.
I agree. I read the affidavit. I do think there's probable cause. And I think that whether that argument can be made, I don't think it goes to probable cause. But like I said, I've been anticipating that argument at some point. So does the state wish to be heard on bond?
Your Honor, state we just asked for a reasonable bond, understanding that the mask was a surgical mask, which is within the COVID era. However, we have had no guidance from the DCAs or the Supreme Court as to how to handle that in regards to the mask enhancement. And in regards to that, the mask is just an enhancement. So count 1 and count 2 are both just F1s. So state would just ask for a reasonable bond as all charges as he's otherwise entitled to it.
All right. I think that the bond as set is extremely low given the facts in this case. However, I'm going to stay those bonds. So your bond on count 1 is $10,000, your bond on count 2 is $10,000, and I will treat the other 2 as subsidiaries. So your bond is $150 on count 3 and $100 on count 4. With special conditions, you can have no contact with any victim or witness in this case. Do you understand what no contact means?
Yes, Your Honor.
You can't possess a weapon, firearm, or ammunition. You can't possess or consume any controlled substance without a valid prescription.
Yes, Your Honor.
Are there any other conditions the state would request?
If I could say one thing.
Hold on. You can say anything you wish. However, everything you say right now is recorded and can be used against you later.
No, Your Honor, I was trying to make sure the scene wasn't of.
It's not. I checked that, but.
I was double checking to make sure it wasn't of importance.
No, I'm glad.
Nothing further, Your Honor.
All right, so after speaking with your attorney, you don't have any other comments you want to make today?
No, Your Honor.
Good luck, sir. That's 21 CF 15084. I'll find his refusal a willing waiver of his appearance today. I'll appoint your office to represent him, Mr. Brantz.
We'll waive the appearance.
All right, I'll stay the bond at $5,000. No return to the scene, no contact with any victim or witness, can't possess a weapon of any kind, firearm, or ammunition. Good afternoon, sir. Please tell me your name.
Marco Joel Torres Quinones.
Sir, you're here in 21 CF 4623, charged with, well, let me ask. The state filed an information? I just want to make sure it's the same charges. All right, the state filed an information charging you with trafficking in 4 grams or more of fentanyl, trafficking in 28 grams or more of fentanyl, trafficking in 14 grams or more of fentanyl, trafficking in 28 grams or more of fentanyl, unlawful use of a two-way communication device, and unlawful, 2 counts of that, unlawful use of a two-way communication device. So that's
the information.
6 counts?
I'm sorry, Your Honor, that's the information that's been filed?
Yes, I'm reading off the information because I wanted to make sure that that's the same charges as arrested. I'm not sure it is, but that's what they filed on the 24th of June, 2021. So,
Just a moment, Your Honor, to confirm.
okay.
Your Honor, I also see a disposition.
Okay.
Your Honor, can I have a moment to look up the warrant?
Yeah, we need to look this one up too because it says
Dismissed by court.
Judicial Officer Alicia Lattimore. Well, Judge Lattimore does violations of probation and specialty court. I didn't know that she had a regular docket, so,
I think she does drug court too, doesn't she?
oh, she does do drug court? Okay, maybe she does then.
I think so.
All right, hold on, sir. We're still looking this up to try and see if we can understand it. Yeah, I see a disposition.
Yeah, I'm not sure.
Can you look at that?
Ms. Davis, do you know if he was incarcerated in Florida this year, 2021?
I'm sorry. Is on 6.
Do you have any info of where this client was, like as far as other county jails this year?
Either.
I think he was in Polk County.
There's not really anything.
Is there a date of release by chance?
Oh. I'm on the right defendant. It says disposition, but I don't see a document. And it says defendant, Torres Quinones.
Go back to them.
So they moved him from Polk County to here because of the warrant?
Are you still talking about this defendant?
Yes.
Okay.
May I approach?
Yes, I'm sorry. I was talking to the clerk about it, so I missed all of that, just in case I needed to hear any of it.
I was just seeing if Ms. Davis had any information about where Mr. Quinones was. He was in Polk County Jail until he was brought down here due to the warrant.
What
If that's correct.
seeing is he came in with 7 arrest charges. We ended up filing on 6/24 on 5 of them. And then I also see those 5 disposed of also on 6/24. So it doesn't really make sense.
But I don't have a disposition.
I don't-
Neither does the clerk.
I don't either. I just see that there was a disposition. But-
See, on 6/24, there's a disposition, but on
court minutes.
7/7, there's a capias issued.
Yes.
But the capias is a probable cause capias. It's not a failure to appear.
Weird.
Or 6 counts.
It's where there's a disposition, but no court minutes or hearing or, because it wasn't a null pros by the state, it was dismissed by court. But I also don't see entering into drug court or PCD or anything like that, which is usually when our system says dismissed by court, is completing a court program.
Yeah, I don't see any of that.
Weird.
All right, sir, here's what I'm going to do. I'm going to stay your bonds. So on counts 1, 2, 3, and 4, your bond is $100,000 each count. 5 and 6, it'll be $1,000.
Your Honor, there's only 5 counts.
Not in the information.
What I have on the information.
Count 6, information. The information filed has count 5 and count 6. Oh, I see, because in the information, it charges Emerson Hornado on count 5, but not, I see,
So there's only 5 total charges.
on
5
him. I
Yes.
see. All right,
is
so
on
on
file.
count 6, your bond is 1,000. There's no count 5. Well, count. How is it listed?
Okay, so we have it listed, we have count 1, 2, 3, 4. Yes.
All right. You can have no contact with any known drug dealers, no contact with the co-defendant. You can't possess any weapons, firearms, or ammunition, or controlled substances without a valid prescription. I show that your next court date is in front of Judge Lattimore on December 6th. I don't know if that's right or not, Mr. Brantz, but can you make a note for your colleagues to see if you guys can figure out
Yes, Your Honor.
where he's going and when?
Yes.
All right. All right, good luck, sir. And that's which defendant? Okay. Got it. Good afternoon, this is Judge Gibson. Who do I have on the line?
Hello.
Interpreter, my ID number is 208468.
Hi, has the interpreter been sworn today?
Not in this court, no, Your Honor.
Please raise your right hand to be sworn.
You solemnly swear to translate from Russian to English, from English to Russian to the best of your ability.
Yes, I do.
Thank you.
All right, good afternoon, sir. Please tell me your name.
My name is
Добрый день.
Микола
Назовите.
Яковкин.
Sir, do you need the services of an interpreter?
Переводчик вам сегодня требуется?
Да.
Yes.
All right, then please wait until the interpreter speaks and then speak.
Тогда, пожалуйста, ожидайте сначала, когда переводчик переведет, потом говорите.
Can you please tell me your name?
Микола.
Повторите ваше имя и фамилию.
Микола. Mykola.
Микола.
Yeah.
MYKO.
All right, sir. You're here in 21 CF 15094, charged with burglary of a structure with assault or battery with a weapon.
This is the interpreter, Your Honor. Please repeat the number.
21 CF 15094.
Thank you. Вам предъявляют обвинение по соответствии со статьей 21 СФ 15094 с ношением оружия, нападения и кража.
Вот чего кража? Я ничего не воровал.
Sir? All right, what did he say?
But I didn't steal anything.
All right, I understand. Let me tell you why you're here.
Давайте я сначала вам объясню, почему вы здесь.
And allow your attorney to give you some advice.
И потом позволю вашему адвокату дать вам совет.
Because you're also charged with aggravated assault with a weapon,
Потому что вам предъявлено обвинение злостное нападение с оружием,
armed trespass in an occupied structure,
вооруженное пересечение собственности, вооруженное пересечение собственности,
and carrying a concealed weapon.
также ношение оружия при себе, спрятанное.
At this time, I'm going to appoint an attorney to represent you.
Я сейчас закреплю за вами адвоката, чтобы представлял ваши интересы.
Yes, Mr. Brantz?
I was going to ask for a moment, but I know we need the interpreter. Let me see, just for a second, Your Honor.
Okay.
All right, thank you, Your Honor.
All right. Sir, you're here today for a determination of probable cause and bond.
Вы здесь сегодня по той причине, чтобы определить, была ли веская причина для установления суммы на поруки.
This is not a trial.
Это не является формальным слушанием.
Or evidentiary hearing.
Или слушание с представлением доказательств.
You can say anything you want to say.
Вы можете сказать все, что желаете.
But everything you say is being recorded and can be used against you later.
Но все, что вы говорите, записывается и может быть использовано против вас в будущем.
At this time, you don't have to say anything.
Сейчас вам ничего не нужно говорить.
Mr. Brantz is representing you for this hearing.
Господин Брент представляет ваши интересы на слушании.
Did you want to give him some advice on the record?
Хотите ли дать ему совет по протоколу?
The best advice is to remain silent on the facts of the case, as all of this is being recorded.
Мой совет, пока сохранять молчание относительно фактов случившегося, потому что все, что вы говорите, записывается.
If you're held here with no bond today, you can give us a call and we can have a hearing to set bond later.
Если вам сегодня сумму на поруки как бы залог не установят, вы можете позвонить нам, чтобы мы поговорили, чтобы организовать вам залог.
But it's best to remain silent on what happened until you talk to your attorney.
Но лучше всего сохранять молчание, пока вы не поговорите со своим адвокатом.
Understood?
Вы поняли?
All right, let me ask Mr. Brantz, did you have any arguments to make on probable cause?
Господин Брэнс, хотели бы вы представить свой аргумент по вероятной причине?
Not as to the charges, Your Honor, no.
Нет по этим обвинениям, Ваша честь.
I reviewed the affidavit. I agree with you, Counselor, and the affidavit says there's surveillance video.
Я согласна с вами, адвокат. Я просмотрела афидавит, там указано, что была видеозапись случившегося.
I do find probable cause for the charges.
Я нахожу вескую причину по этим обвинениям.
Let me ask the state if you wish to be heard on bond.
Я спрошу представителя государства, если они хотят остановить сумму поручительства.
Yes, Judge. Given that count 1 is a first-degree felony that's punishable by life, state is asking that you hold him no bond pending an Arthur hearing.
Да, Ваша честь, в соответствии с сказанным, мы предлагаем не устанавливать сумму сумму на поручительство до проведения слушания.
Any argument from the defense?
А защита, у вас есть какие-то аргументы?
Your Honor, you are able to set bond on that charge.
Ваша честь, вы можете установить сумму на поруки по данным начислениям, по данным обвинениям?
I'm sure Mr. Yankovkin would like me to mention that the alleged weapon was a fake gun, a BB gun. I'm not sure. I would have you consider that in your determination.
Когда вы будете принимать решение, пожалуйста, я уверена, что мой подопечный, мой клиент согласится с тем, что я бы хотела упомянуть, что оружие не является настоящим, как бы игрушечный пистолет.
I read that.
Я это прочитала.
However, because the allegation is that he committed burglary with an assault with a weapon, I do think there's probable cause for that charge.
Да, но сам факт, что я вижу, что ограбление с нападением с оружием, я нахожу вескую причину по этим начислениям.
So at this time, I'll hold him at no bond.
Поэтому пока я его оставляю под стражей без суммы залога, чтобы выйти.
On that charge,
по этому начислению.
He would be entitled to an Arthur hearing to set bond in front of the trial judge, Your Honor.
Будет ли у него возможность поднять вопрос относительно сумму для того, чтобы выйти обязательства, когда будет с ним разговаривать судья, проводивший слушание?
Yes, he is.
Да, у него будет.
At this time, I will stay the other bonds at $2,500 on count 2.
Я тогда установлю $2500 сумму по второму обвинению.
$150 on count 3.
$150 по третьему.
And $100 on count 4.
И $100 по четвертому.
His bond conditions on those 3 counts are you may not return to.
И условия отпуска следующие. Вам нельзя возвращаться.
3300 West Colonial Drive.
3300 West Colonial Drive.
Mr. Yakovkin, you also cannot possess a weapon of any kind, a firearm or ammunition.
Вам нельзя иметь никакого оружия, ни патроны, никакого рода.
And you cannot have contact with any victim or witness in the case.
И вам нельзя вступать в контакт ни со свидетелями, ни с теми, кто числится по этому делу.
On that green piece of paper is a phone number.
На зеленом документе есть номер телефона.
You want to call that number and ask to speak to the attorney assigned to your case.
Позвоните по этому номеру, чтобы поговорить с адвокатом по этому делу.
They'll be able to get an interpreter.
И они смогут предоставить переводчика.
Did you have a question for me now?
Просто у вас ко мне есть?
I didn't hear the beginning of what you said. I'm sorry.
He's asking if he can call his mom to help with bond.
So I can get out.
Oh, you'll be able to make a phone call? Yes, but you cannot bond out.
There's no bond on this first charge. You have to have a hearing to set bond in count 1. So that's why you want to call us.
That attorney.
Hey, Madam Interpreter, interpret that, please.
Yes.
То есть вы можете позвонить маме, но сумму залога по первому обвинению не выставляется, пока не переговорит, пока не будет вас слушать судья по слушанию.
So you want to call us at that number and your mom, but you definitely want to call us about count one.
То есть вы позвоните нам и своей маме, но в первую очередь позвоните нам по первому обвинению.
And say you need a Russian interpreter.
Скажите, нужен русский переводчик.
I'm sorry, Your Honor, if I sounded like I cut you off.
No, I wanted to say those things, so I'm glad you did.
Спасибо, что вы сказали все, что нужно было.
Do you understand?
Вы поняли?
Да.
Yes.
Well, and then the Russian interpreter, and then call mother some money, and
We'll help.
Ask for a bond hearing.
Arthur,
Попросите слушание, чтобы вас выпустили под залог.
All right, good luck, sir.
Вам удачи.
Wait. Ask me again.
I can call downstairs, same floor as there, or I can go down.
Where are the phones? Are they downstairs? Yes, the same place. Yes, sir. Good luck.
Да, в том же месте. Вам удачи.
All right, thank you. I believe that's all we have for the interpreter.
Thank you. We appreciate your business. Have a good day. Bye-bye, Yona.
You as well.
Thank you.
All right, sir, please tell me your name.
Antonio Ubilis.
All right, Mr. Ubiles, you're here in 21 CF 15060, charged with burglary of a conveyance and loitering or prowling. At this time, I'm going to appoint an attorney to represent you. Mr. Brandt, did you have an argument?
My only concern, Your Honor, was usually with the loitering and prowling charge, it's to prevent any future criminal activity. Here we did have another charge, a burglary of a conveyance. And so I feel the loitering and prowling, the future criminal activity was allegedly committed. But that's in your discretion to determine whether that charge is compatible with a burglary charge, like in this circumstance.
I think there's probable cause. I mean, if you're arguing it should be subsumed by the burglary, that may be, but that'll be a decision for the state.
Yeah, I don't know if it's a merger. I don't think it's a merger issue. That's why I didn't argue it like it should be, but
Right.
I think a lot of the case law that we've seen is there's a point where the future criminal activity is prevented by the police.
The interception of the.
Not
Right.
dispelling their fear, and so they charge loitering and prowling, but if there was some future criminal or some criminal activity, you charge them with that. But I suppose that is a down the line question.
I think it is. I think there's probable cause, but again, I don't know what the state will eventually choose to do with this charge. Sir, there is probable cause for these charges. I'll stay your bond at $3,500 on count one and $100 on count two. With special conditions, you can't return to the
Marriott Hotel at 7499 Augusta National Drive.
or the Hilton Garden Inn at 7300 Augusta National Drive. It was in two different locations. You also can't have contact with any victim or witness in this case. Do you understand?
Yes, ma'am.
All right, sir. I show that he's out on bond for a battery. And he's currently on probation.
Yes, Your Honor, the battery, the 21mm 4166 was an arrest back in June. We filed it in July for a bat DV. The alleged victim being his father.
All right, at this time, sir, I'm going to revoke your bond on that. Good luck. Good afternoon, sir. Please tell me your name.
Is that Michael and Watkins?
21 CF 15091. Sir, you're here charged with possession of cocaine. I'm going to appoint an attorney to represent you. There is probable cause for the charge. Your bond is $1,000. With special conditions, you can have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. I show he's out on bond for possession of cocaine, among other charges.
1 second, Your Honor.
All right.
12813. Yes, Your Honor. That case came in possession of cocaine, attempted destruction, and possession of paraphernalia, and does not appear that state has filed yet.
From September?
September 26th. It doesn't appear that I have an FDLE report in case management.
He's got 3 prior failures to appear, 6 prior violations of probation.
Your Honor, I believe that, if I may.
Yes.
The last failure to appear from 2018, I believe he was a minor or juvenile.
I think most of his record is juvenile because he's 18.
However, all of it will still be on his record as it's been within 5 years.
I understand, just to the failure to appear point.
It still goes to his willingness to show up for court and comply with court orders.
Mr. Watkins, I'm going to revoke your bond in that case. You're going to ask your attorney to file a bond motion in front of the trial judge because you were out on bond for possession of cocaine and you got arrested for another possession of cocaine charge. Look, Mr. Watkins, I don't know you and I don't know your story, but you're only 18 years old. I'm looking at your record. You have a juvenile record a mile long, but you're not a juvenile anymore. So now every time you get arrested, you're charged as an adult. This possession of cocaine is punishable by up to 5 years in prison. The one you're out on bond for is also punishable by up to 5 years. Plus, what's attempted destruction of evidence?
It is an F or an M1.
All right, so that's 1 year, and the drug paraphernalia is 1 year. Those are the maximums. Mr. Watkins, I hope you make some different choices. I really do. Call your attorney right away, okay? Good luck, sir. You have a question? Go ahead. So on that green piece of paper, there's a phone number. Call that number and they'll tell you which attorney is assigned to your case. Good luck, sir. Good afternoon, sir. Please tell me your name.
I'm Daryl Charles Willie.
I didn't get all those. Okay. You're here in 21 CF 15050, charged with possession of cocaine and drug paraphernalia. There is probable cause, and I'll appoint an attorney to represent you. Your bond is $1,000 on count 1, $100 on count 2. With special conditions, you can have no contact with any known drug dealers, and you can't possess or consume any controlled substance without a valid prescription. In 20 MM 7138, you're here because a capias was issued for your arrest for failing to appear on charges of battery. The bond authorized on that capias is $1,500. I'll appoint an attorney to represent you in that case as well. I show that he's out on bond.
Yes, Your Honor, and state has filed.
Okay. Are we on the matter? Very first day I had two. Once the lawyer seen it was one lawyer, you seen him in 2020. You cleared that. No, I really. That's what I'm saying.
Wait, what? You can't plead. That was just 8 days ago.
Your Honor, as to the out on bond case, would you consider revoking and doubling as it's nonviolent? I know he's here on a charge with similar circumstances. I would just have you consider that.
I'll take no action on that case.
Thank you, Your Honor.
Good luck, sir.
Thank you.
Yes, sir. So I changed that.